Hello, everybody. So, yeah, I'm gonna get started, I guess. I just got my stream set up to do a scheduled. This sounds ridiculous, but I just figured out how to do a scheduled. How to do a scheduled stream, which I should probably know beforehand, but I think it should be good to go now. If anyone is here, just let me know if you can hear me. Hey, factual. Do I sound okay? Okay, cool. Thank you. Yeah, I got it. So yeah, I was. I didn't see your response. There's a little bit of a delay. Thanks. Yeah, so I was looking at this probably maybe 2 weeks ago when there was an issue with. There's one filing that I didn't really care for, and I kind of made a comment about it. Somebody online told me to. Somebody who I respect told me that I shouldn't, be so critical because it's a death penalty case, and they've been together for a long time. Yeah, no problem. So I actually didn't. I kind of let it slide one time without being too critical of it, but this last one was really. It's bad. It's really bad. So the issue, I don't know exactly how far the issue goes, how far back it goes, or how extensive it is, but essentially a huge portion of this motion and the amended motion in a second, they're just cut and pasted, and they're not cut and pasted well. So in this motion, she's citing to law. She found this one example. She found this brief from 1999. And she cut and pasted a section from that brief. But the problem is that the law's changed since 1999, so she's citing the law that just doesn't exist, or it's been renumbered in such a way that, for example, there's one section that's supposed to refer to the conditions of release for pretrial detention in serious cases, and she's intending to cite to that section, but it's actually citing to a section that's about children getting into a fight at schools and how bond works for people who commit crimes at schools. So she's just not writing the entire motion, not reading the motion, not proving the motion, and the motion cites the law that doesn't exist and doesn't support her client's release, and does it while in a way that's likely to antagonize the court. But that's kind of the top level conclusion. I don't know exactly how far it goes, so I was going to start with the more recent motions and show what I found, and then if people are interested, I thought we could go back through to some of the other motions that she's filed in the past, because I know there were problems in those as well. And yeah, that being said, let's get started. So there's one thing I want to show with this. This is the first version of the motion that was filed. You can see Yeah, right here. On the 27th at 11:22. And it looks mostly okay. This is kind of a weird mistake, but it's not a big deal. It's not bold there, but if you go all the way to the end, you can see that there were just these notes left in at the end of the document. The document is here, and it just keeps going. And this isn't a huge deal. I mean, these are just notes that were copied into the body of the document, and you forgot to delete them. But still, they're trying to kill your client. Don't make these mistakes. But anyway, the operative version that we would be looking at is this version here. So you can see it's about, what is this, 15 or so minutes later. Hold on, let me make that bigger for you. Yeah, there you go. So yeah, you can see it's about 15, 14, 13 and a half minutes later. And this is now the amended motion. And the amendment was just to get rid of the notes on the last page. Again, not a big deal, but when I get into the context of the motion, I think I'll understand why it's not... It's a sign of things to come. Anyway, so you can see it's the amended motion, but they didn't fix the bold, which makes me insane. And they didn't change the name of the motion in the body, so they actually amended it incorrectly too, so it's still wrong. But anyway, this is just nitpicky stuff. And I hope I didn't write anything in here that's gonna get me in trouble, because sometimes I write comments, usually about prosecutors. Okay, good. I think I'm not getting in trouble. So I'm just going to read through this, and then I'll get into it in more detail. And just for context, Melly he's been being held without conviction for almost 7 years. He had one mistrial. It was a hung jury, but he's been in jail for 6+ years. Without bond. So here comes now the defendant, Melly, buying through counsel, and files this motion for rehearing of order. I don't know if that's how they say things in Florida, but Florida's weird, so that probably is right, actually. Anyway, in case involving capital offense or an offense punishable by life imprisonment, the procedure for determining whether the defendant has a right to bail is set forth in State versus Arthur. Which requires the state to produce evidence greater than the mere filing of information to show that the proof is evident in the presumption great of the defendant's guilt. They'll use this phrase, proof evident, presumption great, a lot. And if you watch the videos of the hearing, they'll just shorten to that. Basically, just means there's strong evidence of the guilt of the crimes charged. Where the state makes such a showing, it then shifts the burden to the defendant to show that he should still be entitled to bail. So, I don't know, I guess we just do this as I go, actually. So this looked weird to me. I didn't know why there was a colon here. And also, it was odd that you can see two different citation styles, or just formatting. And that's not a big deal, but I noticed that in the past. Hey, Aaron. How's it going? Does anyone here know the Melly trial, by the way? I don't really know it particularly well. I just sort of follow it because I don't like Danny Pola. And he has a mask on, and it seems a little dramatic. But yeah, so this colon was weird, so I was trying to figure out what the deal was. So I looked at this. Let's see if I can get this to work. I looked at this case here to see what the citation was. Okay, let's see if I can do this correctly this time. Yeah, I did too. Actually, it's funny. I was watching his coverage. I was watching Factual. I said I did watch Cuff Boy's coverage. I did too. And when I watched the video about the motion hearing, I thought I was on the wrong video, or that like he messed up and mislabeled it or something. Because I didn't. They didn't actually talk about the motion until, or the motion for bond until like the last tiniest segment of the video. It was wild. But yeah, his coverage is really good. Anyway, so this is the case that that was cited to. It has the language here. And I was skimming through it, and it said, let me see here. So, let's switch back and forth. It's just a cut and paste. It's a direct quote. She's just cutting and pasting the language from the opinion. And that's where the colon comes from. You can see it says entitled to bail colon. Once the state makes such a showing. Let's start this sentence. Where the state makes such a showing, then shifts the burden of the defendant to show that he should still be entitled to bail. And that's the same sentence. So it's just cut and paste, which, you know, if you're going to quote something, that's fine. I don't think it's an inappropriate quote. But it's a side of things to come for sure. And here we go. Okay, next section. Let's keep going. Let me see. Though Arthur and the rules of criminal procedure provide for differing inquiries and burdens of proof, as a practical matter, they are intertwined. I don't know how they're... Okay, so we'll get to that. Thus, an accused charged with a capital offense or one punishable by life imprisonment nevertheless is entitled to have the question of his or her release or detention determined under federal or Florida rules of criminal procedure, section 3.131 and 32, absent an adequate showing by the state under Arthur that the proof guilt is evident with presumption great. I don't think I checked this one. I want to see if So we're looking for evidence. So let's go back. Nevertheless entitled to have... Okay, I actually didn't notice this one the first time I looked. Although Arthur in the rules of criminal procedure... Yeah, I think this whole paragraph is just a cut and paste. Yeah, it is. So I think this entire section is just cut and pasted from the opinion. It says, although Arthur and the rules of criminal procedure provide for different inquiries and burdens of proof, although Arthur and the rules of criminal procedure provide for different inquiries and burdens of proof, practical matter intertwined, just an accused charge. Yeah, this is just a verbatim quote. It looks like she just added this part here. Yeah, she just added the citation. This just says 3.13132. She just added the this section. Well, the SEC. It's the South. The SEC makes sense, I guess. So that's just a completely cut and pasted paragraph as well. That's an absent adequate showing. Yep, that is just entirely cut and pasted. Okay. So, we haven't written anything yet. We're getting the third paragraph. Mr. Demons exercised this right to pretrial release. I think it just said there wasn't a right to pretrial release. Either entitled to have the question of release determined under certain rules. But in any case, released by filing his second motion for pretrial release following mistrial, establishing that the court is not precluded by a proof evident presumption of great termination from ordering the release of Mr. This has to be cut and pasted too. Of Mr. Jones upon reasonable conditions. Rather, the trial court still has discretion. Yeah, this is definitely cut and pasted as well. The trial court still has the discretion to grant or deny bail if the defendant can prove. Yeah, this is just an extra space here. There's probably a break here. The defendant can prove there are conditions of release, can reasonably protect the community, assure the presence of the accused, or assure the integrity of the judicial process. Factual eye, that's exactly right. It is a death penalty case. They're trying to kill her. They're trying to kill her client. And that's not something, this is not the case. This isn't okay in any case to do this as a lawyer, but they are trying to kill her client. And she's not writing or even really proofreading. Obviously this isn't the trial itself. This isn't the life or death part, but yeah. I didn't see the bottom part. I watched a couple of hearings in the trial, but no, almost nothing about the first one. I'm kind of in the same boat, except that Danny Polo came in wearing a full shiesty. Yeah, that got my attention too. Danny, it's just like, it's a white dude, and he's talking about who he thinks to be Bloods, and I don't think the mask is what is hiding his identifying feature with respect to the blood. They're gonna tell that it's a chubby white dude. They don't have a lot of chubby white dudes in the Bloods. The last I checked, I could be wrong. It's 2025. Things change, but I feel like he'd still be identifiable if he was trying to infiltrate, Melly and his friends. And also just everything about his demeanor is really, I really hated this motion. It's barely a motion. It's bad. Anyway, I don't remember if I checked this one. I feel like this is also plagiarized. Let's see. Well, not plagiarized, but it's not, I wouldn't call it plagiarism because it's not really an academic honesty issue, but cutting and pasting for sure. So let's see here. And let me see. Well, I'm getting this case up. I think one of the things that bothers me about the way this has been litigated is I think Judge Fine wanted to... He was not happy with the state, and I think he was ready to show them... He was ready to show them that, and ready to sort of not punish the state, but show that they can't just keep playing with him. And then Melly's team came in and just... They didn't take it seriously either when they had their chance. And Judge Fine can be sympathetic, but you have to give him something to work with. So let's see if this is right. What part? I'm going to say this. The trial court still has the discretion. There's no way that that's... What if I was wrong? That'd be embarrassing. Yeah, definitely. Suggestion to grant or deny bail. I wonder if I'm wrong. Interesting. Can prove the conditions. reasonably protect the community. Let's see this here. Can't we spend sure? If no conditions, police can protect the community. Assure the presence of the accused. Just 1127. 11:30. I was sure of this. I don't want to give up on this because I don't want to be wrong. That would be upsetting. Let's see. The portion said, community. Man. Okay, maybe I was wrong with that one. It's the first time for everything. Well, let's keep going. 4. The state did not file any pleadings, traverse, or a motion. The state filed a motion for pretrial detention. C. Armstrong versus state. This is the other one that made me crazy. This is almost too nitpicky that it's just gonna make me sound like I'm hating this, which I am. But once you do the full citation like this, the full length citation, you usually don't do the whole one again. You just do a shorter version, but it's not technically wrong. It's just actually wrong. So let's see here. Okay, let's keep going. A hearing was held on May 6, 2025 on the aforementioned motions. Neither evidence nor testimony was presented by the state. Rather, they relied solely on the transcripts and evidence of the first trial. This isn't a big deal. The court just took judicial notice, so I think they're just saying that they didn't submit new evidence, as opposed to relying on the past evidence. You are never wrong. You might have sought somewhere else. Ooh, that's a good idea. Discretion is something that there's, man, no. I actually might have been wrong. That's incredible. Okay. Mr. Devins was sanctioned. Also, I gotta say, I don't want to, comment on anybody's names. Like, everyone's name is interesting and has a history and should be respected, but it's not convenient. That's all I'm gonna say. It would be an easier sell if it wasn't Devins. Mr. Demons was sanctioned and not allowed to present testimony of his witnesses. This discovery sanction is discussed further in detail. This makes me sound... I can't read because the words are wrong. This discovery sanction is discussed in further in detail. Oh, it's supposed to be a comma. In further in detail below. Okay, I got it. I was wrong a second time, but not really. Despite not being allowed to introduce any... See, now you're just saying... This is saying, fuck you, Judge. You're blaming the judge now. I am displeased. Did I say I am displeased? Because I am displeased. I am greatly displeased. No, I was right. It's in further detail below, not in further in detail below. They gaslit me. I gaslit myself. also known as just being stupid. This discovery sanction is discussed in further detail below. God, this has void ab initio vibes. I was so mad when that happened. Okay. Despite not being allowed to introduce any testimony, they just fucked it up. The undersigned presented all of the usual factors that would be used to authorize pretrial release, which included the following. Don't say the usual, just the great, very definitively sufficient. Aaron, yeah, sometimes, I mean, I don't have an office anymore, but when I did, I would have to turn my back. Aaron said, I think I might just be annoying about grammar, but I read all my motions aloud just to be sure it makes sense and I haven't missed any errors. Yeah, that's a really good idea. I had a friend, he worked in the next office over, and he used to read every sentence in his motions from finish to start, because it forced him to get out of the rhythm of just reading through and, confirmation bias, and he would actually proofread everything, every single sentence, and not just float your eyes over it and assume that you know it's there. Anyway, a monetary cash bond, which would be paid by, there's an apostrophe missing there, Mr. Demons recording label. Footnote, when assessing the financial circumstances, it is appropriate to consider the willingness and abilities of the accused's family and friends to contribute to his bail. The label is neither his family nor his friend. Gotta write that better. There is an extra... This is wrong. There's an extra bracket here. This looks like it's from Head Notes. I bet this is a Westlaw Head Note. She copies from those sometimes. Anyway, this made me crazy. They just switched the formatting. A residence has been secured for Mr. Demons. He would reside with his brother, Brandon King. Brandon King is also known as B-Slime. He's also a rapper. There's a B-Slime in YSL. They're different B-Slimes. Aaron says same, and I usually end up revising as I'm reading. I do that. That's where most of my mistakes that I didn't catch were due to making revisions when I should have just been reading it. And I just spent too much time trying to get it right, and then I messed it up by fixing something. Anyway, so there are two B slimes, and it's Young Thug. I can't know if it's his brother or his cousin, but it's Young Thug's brother or cousin, and Young Thug did a song with Melly. So he himself has a brother, a relative named B-Slime, a rapper named goes by B-Slime, and Melly has a brother that goes by B-Slime. And Melly's B-Slime did a song with Young Thug. Am I doing this right? Yes, I think. And they actually all of the late websites credited the wrong B-Slime. I'm confusing myself just trying to tell this story. I can't even remember what happened. There are two B-Slimes, and B-Slime's last name is King, and Thug also has a brother with the last name King. I was convinced that they were related or something, because they have B-Slimes and Kings and they rap together and they live in adjacent states, but no, they're just not related at all. So that was a fun several hours that I spent trying to figure that out. Anyway, Mr. Demons would be fitted for a GPS ankle monitor by a court-approved vendor to track his location. Mr. Demons would remain on house arrest and be secured by a 24-hour guard on his person and additional guard for the premise of his residence. Mr. Demons would cover all costs of security detail. That's just, there are missing words in that. Further, the security guards, you know what, no. Nope. No. You know, We're getting rid of this. We don't need this. Mr. Demons would remain on house arrest and be secured by a 24-hour guard on his person. And additional guard for the something like that. Yeah, we need a period. Mr. Demons would cover all costs of the security DSO. Further, the security guards would report to the court, defense, counsel, and the state. I think that's what it's supposed to be. It would report to the court, defense counsel, and the state if there was a breach by Mr. Demons. See, this is unconvincing because he's the one paying them. You don't snitch on your boss. I mean, you do snitch on your boss. That'd be funny. Young Thug's nephew is B-Slime. Yeah, that's Jabori's career. I found YNW B-Slime's music. YNW B-Slime was trying to find Mr. Greer's music. Music. Yeah, YNW B-Slime is Jabori's career. That is also the guy that was... He was arrested with Miles Farley when Miles Farley was pulled over by the very real and very legitimate Apex unit. I hate them so much. But yeah, Unfunk and B-Slam are... I feel like they might be brothers or something. I don't know. Anyway. Yeah. You're right, actually. The security team would further be responsible for ensuring Mr. Demons... You gotta figure out the possible situation. To and from court hearings. Mr. Demons would not be allowed to have possession of a firearm. This makes it sound like he's gonna have one, but that he won't be allowed to. Anyway, Mr. Demons does not possess a passport or real ID, and he would not attempt to secure either. See, this... It's supposed to be like real capital letters, so this makes it seem like he's going to get a fake ID. Anyway, the state did not contest any of the proposed conditions. The trial transcripts, along with exhibits contained therein, established that Mr. Demons was born and raised in Florida. His employment and financial resources. Okay. Promotional video introduced to trial would prove Mr. Demons' family ties. Wait, what? The promotional video introduced to trial would prove Mr. Demons' family ties. Employment. Great. Only the last 4 miles is still dealing with that charge. I would pay to be his lawyer for that. Aaron said Miles is still dealing with that charge as well. I would have so much fun defending that charge. I know what else I'd love is the body cam footage. Because I know they're lying. I'm not going to say I'm 100% sure that they're lying about the arrest. And that's not just like speculation. I have actual reasons to think that it was not as they report. I mean, they disagree with themselves, but in addition to that, I am completely certain that the Apex unit is targeting people associated with Young Thug. And in that exact manner, by those exact people. Oh, man. The Apex... We need to do a video on the Apex unit at some point. God, I hate them. Anyway, with that aside, neither the state or the defense provided evidence or testimony established that there were no conditions of release. This is already dumb. Which can reasonably protect the community from risk of physical harm to persons, assure the presence of Mr. Jones at trial, or assure the integrity of the judicial process. That's got to be a quote. Anyway, why would the defense provide evidence that there are no conditions of release that could possibly protect the community? That wouldn't make sense. I'm glad they didn't. Do we want to check this one? I think I want to. Let's see if this is copied. 349 Southern 930. Alcazar versus State. Let's switch over. How did the quote start? Let's try reasonably protect the community. Let's go physical harm. Harm to persons. This looks like it. I'm not saying they're lying. I'm saying they're lying. And it says, I'm not saying they're lying. I'm just saying it's odd that the dog hit on the driver's side of the door and they didn't take it baseline for the tint until a week later. I'm saying they're lying because I'm 100% sure that they're lying about similar things. And I can't say it more without getting in trouble. I'm positive they're lying. They're lying about the dog, first of all. What was his name? Jumbo. He has a name and his name is Jumbo. The tint thing is so contrived. I am positive they're lying. I want to tell why I know they're lying, but I can't yet. Anyway, let me see. I lost my spot. Where was I? If there are no conditions of release which can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused. Yeah, she's just. I think she's quoting the Constitution here, actually. Oh, no, never mind. Yeah, it's Article 1, Section 14. She's quoting the Florida Constitution. Oh. Driver's side of the car. See, this is why I read aloud. Oh, no, I knew you meant. Yeah, they also... Did you watch this, Aaron? I don't know if you watched the stream I did with... Did I do it with her? I did one with Tiffany Adams, Fit Lawyer ETL. We were going through the arrest warrants, the arrest warrant affidavits, and they are bad. The Mr. Johnson, they switched Miles Farley's name to Mr. Johnson halfway through. They switched the license plate numbers between versions. They changed the car. They changed from Marijuana Flakes capital letters to Marijuana Flakes lowercase letters. God, I hate them so much. Anyway, I hope this isn't going to be public and people can find this. Okay, so that part was... Yeah, it looks like this one was just copied. Although it's copied from the Constitution, not this case, which I assume the judge is going to notice because it's, you know, the state constitution. But we haven't even gotten to the bad stuff yet. The state didn't... I apparently thought this was weak. The state did not present any special circumstances. We talked a little... I did about Miles after Young Thug's probate. Oh, you did? I have... I mean, if you know Miles, Aaron says, I did. There was a stream, we talked a little bit about Miles after Young Thug's probation petition too. I sent them to Miles as well. If you, know him, I can say more directly to him or his lawyer, but, oh, God, I was so mad about the Thugs. Here's the thing. I internally, secretly, I hate on Brian Steele because I'm a hater naturally. Like, it's what I do. And I had all this research ready to go from Moontunk about probation revocations. And then, I did it all on my own. And then they try to revoke Young Thug. And what happens? Brian Steele uses all of the cases that I was going to use. And now if I use them, it's going to look like I took them from him. And that's messed up. He's so perfect. Do you know how many times I've find a case that I'm excited about? Like, oh man, this is going to be so cool. Nobody's going to know about this. And it's just a Brian Steele case. It's deeply frustrating. Brian Steele, he's so perfect. Anyway. Where was I? Talking about Brian Steele's perfection. The state did not present any special circumstances or other factors which would justify a reasoned discretionary decision. Well, it's discretionary to deny pretrial release to Mr. Demons. What? At trial or hearing? I'm sure they didn't give evidence to deny a pretrial hearing at trial. That's just kind of in the words. Anyway. May 12th, the subject matter order. Okay, we're getting to my favorite part here. Was issued finding in part that the court conducted a hearing pursuant to State versus Arthur. Hello, this is your reminder to grift likes for the stream. I'm so much poorer than I used to be. It's so I was oh yeah, for sure. Sorry, I just responded to you at the same time. Istrin was one who said the things about grifting. I was rich. And then I chose to stop being rich. And then they're like, you're grifting. Like, no, I didn't leave Beverly Hills to get rich. God, they're so dumb. Anyway. Aaron said, no, Miles, yeah, and you can message me or something too. I can send you info or whatever. Subject matter order was issued finding part that the court conducted, I read that part, and pursuant to Gallo. This looks weird. This also looks weird. Found that proof of guilt is evidence of the presumption great, and further adopted the reasoning of contained in the prior order. Oh. I thought you were just joking about people saying I'm a grifter. Both work, actually. Yeah. Oh, man, I don't know if I can say it. I was about to say, can I say smash that like button? I don't think I can be a smash that like button guy. I need to come up with some kind of legal thing. Oh, my goodness. This is definitely either copied and pasted or copied and pasted from notes. Found proof skill was great and further adopted the reasoning of. This is supposed to be a case name, isn't it? Reasoning of contained in the prior order, denying the defendant's motion to set bond. Tap that. Tap that like button like it's a Crash Daddy. Oh my goodness. Object to the dislikes. If you don't like this video, I will literally sue you. Not really, but also really. It's not a set bond motion here. The first order. You can't call stuff the first order. That's a thing already. That's Adam Driver. So no. The first order. They proved me wrong. I'm pretty sure there's something in here that's shady, but we gotta keep going. Anyway, the first. I was thinking about Adam Driver and Star Killer Base and the Saturday Night Live. What's his name? Kylo Ren is my boss. Anyway, that's not at all relevant. The first order state in part is exercising its discretion under. They formatted this differently than they did up here too. This one. which isn't a big deal, but it's the sort of thing judges will notice, and it will make them think you don't care. It will look sloppy. First order stated in part that it was exercising its discretion. The first order does not have discretion because it's a piece of paper. Under Florida rules, criminal procedure, in denying Mr. Demens' pretrial release, B3 provides a list of factors for the court to consider when determining whether to release a defendant on bail or other conditions. Okay. The first order further states in part the offense charged is of a serious nature. Okay. Defendant has been, why is it in bold like this? Defendant has been charged with a violent offense involving the use of a firearm which resulted in the death of 2 people, and as such poses a danger to the community. His prior felonies, has been affiliated with violent gangs. Hold on a second. There you go. Although the co-defendant was granted bond by the predecessor court, the evidence against co-defendant is qualitatively different from the evidence against the defendant. The defendant's adduced demonstrates that the defendant was the likely shooter. Okay. Wait, what is... Okay. There's just a space here. Oh, I need to make this smaller. Nah. I just got to the Brian Steele. Trent says nested. The... Oh, the... Oh, I see. Okay. I'm not sure which part you're talking about, but that makes sense. Kat, no, Williams, I just got to the Brian Steele rant. I mean it too. I do. I mean everywhere. I hate Brian Steele. I don't, but I in a truer sense, I do. I hate how stupid and cute he is. Oh, gangs. Okay, yeah, I was just joking. I didn't know there's an actual nested quote there. Let me see. The first order. This is so funny. The first order. The first order. Yeah, all right. So this was contained in Florida rules. There's just an extra space here. They copy and pasted this, and it took the spaces out, and they just moved the space over in the wrong spot. I feel like I'm diagramming a play like I'm John Madden here, except it's lame. Okay, first order wrongly states the defendant has prior felony convictions. This is from... The first order was from 2 years ago. I know he's the GOAT. That's Free Thugga says Steele is the GOAT. I'm aware. And he's cool, too. He's both nerdier than I am and cooler than I am. I pick one. Pick one. God. I'm losing my train of thought here. The first order wrongly states that the defendant has prior felony convictions. Jamel Demens. Oh, right. I was saying the first order wrong that's from years ago. It was from September 22nd, 2023. So when they're contesting the contents of this... I just lost somebody's comment on there. Anyway, I was saying when they contest the first order and the contents of the first order is... That's true. They're contesting something from years ago. This is not the time. The time, like, if you knew there was something wrong in the order, you should have brought that up at the hearing and explained why it was wrong and argued against it. Let me see. Someone's been convicted of misdemeanor possession of marijuana and paraphernalia as an adult. No evidence has ever been... Did you say adduced up here? I would have matched that. No evidence has ever been produced, either at trial or at hearing, that would support such finding of prior felony convictions. Moreover, any felony... You just said... Any felony adjudications would have been when Mr. Demens was a juvenile. That's not convincing. It's like any felony would have come. Like, you don't know whether they're there or not. If they're there, address them. And if they're not, say they're not. It just seems deceptive. Or lazy. Flush section precludes the state from using a delinquency adjudication to satisfy its burden of proving a prior conviction for a dangerous crime under 907-0414B. I think this is the fucky part. Let me see if I have 907-041 up. Nope, we're not there yet. I was wrong again. Florida courts have found in analogous situations that I would love to know what these analogous situations are. I wouldn't want these lawyers for a parking ticket, says factual lie. Never mind a death penalty case. They're actively hurting this sort of thing. It hurts the client, because if you're not going to seriously ask for bond, then just don't do it. It's just a waste of time. If you're not going to do it well, just don't do it. I just saw another error when I was saying that. These citations are... This is fine. Oh wait, maybe I didn't. Paul versus Jenny, Subnom. Never mind, this is fine. Have found an... I want to look at this case really quick. I want to look at Moody versus Campbell. I want to see what the context of this analogous case is, because I don't know if it's analogous. So I'll switch for you. Petitioner, who is being held without bail, awaiting trial, sought writ of habeas. The district court held the petitioner's delinquency adjudications did not justify pretrial detention on ground that petitioner had been convicted of dangerous crime within the 10 years immediately preceding the date of his or her arrest. Delinquency adjudication, while a minor, did not just... Oh, so they're saying, in this case, they're saying that it's solely... It can't be the sole grounds, not that it can't be relevant. That's a problem. That's not analogous, that's just a different situation. Anyway, there is no evidence before the court that would support the finding that Mr. Demons is affiliated with violent gangs either. I'm going to show you the order real quick. Ooh, I gotta switch back. This is where I would not be happy if I were a judge. Oh man, this is the wrong version. This one? Let's see, is that where? Yeah. Yeah, here we go. So this is the court's recent order, not the. This is not the first order. Definitely the case in a state where a jury's decision to impose capital... Yeah, Aaron, so that's insane. This court's order, the recent one, does not make any findings. The defendant has been affiliated with violent gangs, so the court knows that. It seems like... Oh, no, you're right. Instead, I should switch the screen back. You're right, I did. I was reading the wrong thing when you said it. You're right. It's okay. Finally, with regard to the first order, still funny. The defendant did not present proof of certain facts or testimony which would permit... I was apparently confused. Which would permit the circuit court to use its discretion to grant pretrial release under sufficient... I'm confused again. That's the Of course they didn't. Why would the defendant present facts that would... With regard to the first, the defendant did not present facts or testimony which would permit the court to grant pretrial release. That's a bad thing. You want to do that. Rather, defendant relied only on the evidence in trial. So the evidence at trial did not include facts that would justify pretrial release. Isn't that's bad? That's that's what you want to do. YouTube channel skip intro. What's that about? Martha Green says YouTube channel skip intro has new video out. I don't know that. What's that about? This case, I know we're going to come back to it in a second. I just want to see if this is one that we can use now. We are looking for discretion to... Yeah, this is... I'll show you. Ms. Liberty, presenting proof of those facts is your... That's... Okay, Aaron makes a good point. I mean, I know it's the thing. Ms. Liberty, presenting proof of those facts is your job. Yes, that's true. And there's such a cell phone later on in this. It's just... Oh, man. I can't even get to the part where I get mad, but without getting mad. Regard to the first order, discretion. Under the clear holding Arthur, defendant still... Oh, I'm doing it again. Under the clear holding Arthur, the defendant still has the option of proving certain facts that permit the circuit court to use its discretion to grant pretrial release under sufficient conditions. Yeah, I think that's what happened, Aaron. I think they just added, they just copied and pasted this section but didn't change it correctly. Follow guard. Arthur. I'm reading the opinion. The defendant still has the option of proving certain facts that permit the circuit court to use its discretion to grant pretrial release under sufficient conditions. Yeah, so they just pulled the text from the opinion, but they didn't understand it and changed it in a way that doesn't actually help them at all. The first order is devoid of any Jedi. The first order is devoid of any findings of fact regarding Mr. Demons being a flight risk or that detention is needed to assure the integrity of the judicial process. Rather, it holds that Mr. Demons poses a danger to the community. I mean, that's not great to be... Okay. In accordance with... Don't say that. Why would they... In accordance with 907-041-5... I gotta check that one too. I know they messed up 907 at some point. Let me see here. In accordance with 907-041-5, the court may so conclude that the defendant poses a danger to the community if it finds that Paul footnote 4 is what I said. Let's see what that means. Okay. The defendant poses danger. It finds that the defendant is presently charged with a dangerous crime, substantial probability that they committed the crime. Factual circumstances indicate a disregard for the safety of the community. There are no conditions of release sufficient to protect the community from the risk of physical harm. Yeah, this is the part that annoyed me. There's Paul footnote 4. This might be the wrong version. No, it's not actually. Okay. This is a case from 99. John Paul. It's French. Anyway, this is a habeas apparently. And defendant's bond was revoked. Defendant filed a habeas writ, held the trial court was required to set new bond. Okay. The court may, yeah. So this is actually these bullets in the brief instead of numbers as they did in the opinion. That's not a big deal. But what isn't great is, I think this is the section that I want to look at. Let's see. But actually, the next one. Yes, this is the next paragraph. This is also a problem, but we'll get to this. This is the good one. Although a finding of dangerous community can be used as a factor in determining bail. Okay, now what is this? No. What? This looks. This part doesn't need to be underlined. This space doesn't need to be underlined. It doesn't need to be italicized and underlined. It should be just take this, and just make it not suck. That's my advice. Yeah, Martha Griffin says that the YouTube channel, the skip intro video is propaganda. I don't know if I have the health to watch that. I probably don't know. Although a finding of danger factor cannot be the entire basis for pretrial detention. This is the one. It's 907-041 4B 4AC. So we're going to go back to a version that doesn't apply. I'll show you this. Here we are, 041. This is Westlaw. If you're not familiar, this is, where we keep all the secret lawyer stuff. So I want to look at the version that was in effect in 1999, when I know that this was written. Anyway, so currently they said 4. What was it? C 907-041 4B 4AC. Okay, so 4 is special conditions. Wait, am I on the wrong one? Right. Okay. Sorry, I thought I was wrong for a second. This is the section they're citing for. Special conditions for certain offenses involving schools or students. I don't think that's what they meant. Factual. I know. It's actually factual. All those tabs. Oh, can you see my tabs? That's terrible. That's, you know what? I can close some of these, but I'm not going to. Not being entire basis for pretrial. So 4B is about schools. Right now, today. But if you go back to, let me see where it was, 4B in 1999, Westlaw is like Patreon, but way more expensive. True. And they don't even make the content. Section 4 in 1999 was this. 4B. Oh, like, why is my computer doing this? 4B, 4AC. That's this part here. I swear to God, Westlaw, if you... They're trying to quote or refer to this But again, I'm not showing you the thing. There we go. What they're citing to, what they think they're citing to, what she thinks she's citing to is this: pretrial detention 4B 4AC. This is from Y2K. This is from the millennium. This is not what the law is anymore. Because my mouse is driving me insane. What the I'm gonna stab something. Special conditions for certain offenses involving schools or students. 4B, there is no 4AC. So because it's 2025 and not 1999, for every 100 likes we'll close one tab. Battery? I feel like I'm getting roasted here, and I'm trying to roast somebody else. How am I the lawyer getting roasted right now? Oh. Kat, I'm gonna need my mouse to be a gamer, and you know, this is somebody's life is on the line, Kat. I'm gonna need my mouse to, you know, deal with the low battery situation. This is a matter of life or death, and roasting other attorneys. But yeah, this is, again, it's 2025, like I was saying. My mouse needs to stop being a little bitch. That's what it is. Thanks, Trin. Yeah. Oh man. I don't even know. Like, oh man, I don't even know where I am anymore. I'm just trying to talk about this death penalty case, and I'm the one, like, I'm not the one fucking this up. Okay, where was I? Jerks. This is all Brian Steele's fault. Ah, right, Sheriff versus Ricks. I don't know why I wrote that. But let's see if I can find out. Actually, yeah, who was it who said Westlaw is expensive? Hey, Kels. It's insanely expensive. It was during when Doge was doing all of their audits. There was a moment where people were thinking that that Westlaw was like a fraud because of how much money it was. It is. But people were genuinely confused at the expense of Westlaw. Okay, here we go. Here we go. Okay, so I'm going to read this. Although finding a dangerous community can be used as a factor in determining bail or other conditions under Florida rules of Prim Pro, copying the entire basis. This is the part that was quoted by the lawyer who isn't me, by the way. Let's slide this over. The court held that although a finding of dangerous community can be used as a factor in determining pretrial, it cannot be the entire basis for detention. So this is what she's taking she's referencing here. But again, it's and this is the code section that she's referencing. But like I said, that is the 90s. That was the frosted tips era. This is not the 90s. So yeah, you're just citing, you're just cutting and pasting from a 25-year-old brief and a death penalty case and citing to law that doesn't exist in a hearing that isn't even, that was your choice to have. And I mean, if you just look at these cases, it's gonna look odd because this is from 92. It's also from 92. This is from no year. This is timeless. Fernie versus State is immortal. You don't need a year. And what are these citations? That's like a shorthand thing that they're doing. Like this, or it's like they're just, I'm starting to think that they weren't trying that hard. I gotta be honest. Anyway, the first order. I just keep thinking about Adam Driver in that SNL sketch. The first order fails to include the necessary pretrial detention findings required by... What the fuck is this? Florida Rules of Criminal Procedure 3.132C2 and sections 9... Why is it italicized? 907, 041, 4H, and then Metzger versus Cochran. I bet that this is going to be in here somewhere, and I bet it's going to be annoying. They did. Yep. They copied it. But they somehow made it worse. Let's see what the case says. While a defendant who has been released on bail may be arrested and committed, the trial court may not thereafter refuse to impose any conditions unless the state proves beyond a reasonable doubt the need for a pretrial detention. That doesn't sound like it says the same thing. I wonder if this is the same. Where's the code section? O41H? (907-041-4H). Okay. 4H. There's not... this is also wrong. This is the old version. And I see what you're saying about the tabs now. This is a lot of tabs. This is an excessive number of tabs. E, F, G, A. Yeah, this is also an older version of statute. And it just looks... it looks like it looks wrong. A judge is going to not notice this because it's like a child that has chocolate smeared all over their face saying they haven't done anything wrong. It's possible, but, you know, it's a fucking child covered in chocolate. And instead of chocolate, it's, you know, malpractice in the face of impending death. Although I guess you don't know what the child's been up to either. Anyway, specifically, the first order fails set forth. The fails are set forth. I'll agree with that. Any findings regarding the factual circumstances of the alleged crime that would indicate disregard for the safety of the community. It's a shooting. It's a double homicide. What do you mean? It's in the chart. Specifically, after all testimony at trial confirmed that alleged shootings were an isolated incident. The double homicide doesn't have to be a repeat thing to be bad. In isolation, he killed one person and then another person. He's not a danger. And according to the testimony of Mark Moretti, in an isolated area. Okay, I'm not even going to do that one. Most importantly, the first order lacks any findings of fact that no conditions of release or bail will reasonably protect the community from risk of physical harm. It's a discretionary thing. Florida, they're formulating it a different way now. Florida rules Crim Pro require an order on pretrial detention be based upon evidence introduced at hearing and must be supported by finding facts and conclusions of law. Let's check that. It's Trenton. Hypothetically, ex-wife and her boyfriend, no one else is really in danger. I mean, maybe. As Alcal said, I really want his lawyer to be better than this. She's falling apart. Yeah, I think the lawyer in the first trial was good, but he might not have wanted to. I don't know why he made the change. And Trenton's right. Yeah, I agree, Trenton. Like, it's possible that if it, in those circumstances, I think it makes sense that you're right, that it would be less obvious, less likely to have a repeat. But, I'd still want to be proceeding from something that's not a double homicide. The bail should replace the G. Yeah, no, I'm not trying to like defend bail or a bond or anything like that. Actually, to the contrary, I think that he should absolutely get bond, which is why I'm less thrilled. I'm unenthused by the quality of the lawyering here. 3.132. What's again? L2. JKL2. Okay. An order granting or denying pretrial detention must be issued after hearing. Okay. Findings. The order may be based solely on hearsay, but must be based upon evidence introduced at the hearing. Okay, it must be supported by findings of fact and conclusions of law. Okay. The order must be made either in writing or orally on the record in 24 hours. Mandatory detention order. The judge must order detention if the judge finds substantial probability the defendant committed a capital felony and based on the defendant's past and present patterns and any other relevant facts, no conditions will reasonably protect the community from risk. Okay. Yeah, no, I agree, Sean. Yeah, I should do a separate bail stream actually, but yeah, I mean, me attack like when I'm mocking this motion because it deserves it. I'm not doing it because the underlying sentiment's bad. It's because it is bad. I mean, it's just this. He's this. Like I joke and I'm laughing about it, but this guy's, lost most of his 20s at this point. I mean, the president hasn't changed, but that's because there was an entire other presidential administration that he was in prison for. Okay, where are we at? So this is actually the first point that is even worth thinking about. This is here the court saying that he listing all the stuff of which he took judicial notice. And see, no, I almost went on a Mooktunk rant. I'm going to anyway. See, judicial notice is you have to say you're taking judicial notice, and then you have to listen and say, hey, is this guy doing state? Are you okay with that? Defendants, are you okay with that? You can't just say, no, I can't say, I can't keep going. There are rules for taking judicial notice. That's all I'm saying. the state's evidence. So he identifies the evidence, he identifies the basis of it. This actually is arguably pretty light in the way of factual findings. But I mean, it's a discretionary order to begin with. He's giving. I don't think there's anything there. Yeah, I mean, there are factual findings in here. It is light. I mean, it's not a bad point. This is the best point they've had so far. It's not going to work, but it's not terrible. It's not terrible. It's the best thing I've been able to say so far. 27. The purpose of bond is to ensure the appearance of a defendant. We've established this. And protect the first order. Protect the community from reasonable danger. First order is insufficient. Melly's better judge than Allen. I think the judge was prepared to. I mean, here's the thing. It's a major risk for him professionally to let somebody out, to let this defendant out, irrespective of whether that's fair or not fair, but I think he was prepared to do it if the case was made, and instead they just kind of disrespected him in the process and their client, and the lawyers weren't serious about the bond, and they're asking him to take a professional risk that when they're not even willing to proofread, it's like the state disrespected him, and he wanted to hold him to account, and then the defense disrespected him too. I'm always down for a sledge rant. The time is nigh. Okay, I'll do a sledge rant. He is objectively right, and he's definitely going to win. And the only thing, and by he I mean we, are going to win. The only question is how long it's going to take, is how long the state is going to keep their claws in him. Because they're clearly wrong, and they know they're wrong. I know they're wrong. And I know that they know that I know they're wrong. Hose long to get. Never mind. It's so obvious. It's so clear once you notice it. There are no factual acknowledgments. There aren't any. They just don't exist. You can just look at the sentence. They're not in there. There aren't any special conditions of probation either. Oh man, I'm easy to bait into these rants. I need to work on that. Because now I just want to keep going. Nope. The first order. You're catching yourself. It's hilarious. Cat almost got me. Because the hose long joke is just. It's broadly applicable. We don't want you to keep going or close tabs. This is so close to becoming a Mooktung stream. Can you believe? Yeah, we're doing this for a second. Can you believe the audacity? The audacity to suggest that I am incorrect? To suggest that I would say something this facile? Aaron, you're supposed to come back and do a stream. Yeah, I decided that was unwise for the reasons that just became apparent. Oh man, I have another stream I was supposed to do. They didn't say you were. Okay, saying sludge is wrong is even worse. That's like saying that my baby is wrong. I am. If anything happens to him, I will kill everybody in the room and then myself. Neither party presented any evidence concerning whether conditions would protect the. This was one of my favorites. Neither party presented any evidence concerning whether conditions would reasonably protect the community from risk of harm. That's a cell phone. You want to do that. The subject matter order states, first order, no, the second order, states that it adopts the reasoning contained in the first order without making any findings of fact regarding the exclusion of the defendant's witnesses and the lack of evidence or lack of any evidence, and it further failed to make a finding of fact that no conditions just what stop People want to states that the defendant, see, now we're doing lowercase defendant, uppercase defendant, then we do demons, then we do defendant again. Florida rules crim, defendant entitled to representation by counsel. This is the best argument so far, actually. That's A+. To present witnesses and evidence. What is this? That implies that this is part of the rule. Pro tip, anytime you say something unquestionable that in Minecraft, that's a good idea. Okay. Mr. Jones denied this privilege because the court sanctioned the defendant and struck his witnesses. I wonder why. The state did not argue the prejudice, if any, stemming from late filed witness list, and no inquiry was made by the court regarding whether giving only 1 day. I can't. Notice of witnesses intended to be called at hearing. Prevented the state from being properly prepared for hearing. The court didn't make a finding that telling them the identity of the witnesses the day before prevented them from being properly prepared. I'm going to go ahead and say that it did because it's 1 day. You don't really need a finding for that. It's a day. You know what? I know this is a lie too. This isn't the right case. I have too many tabs open. You guys were right. This is the case they cited. Fed. Wait a minute. Fed versus state. Yeah, that's right. Defendant was convicted of burglary of a firearm, armed robbery. That sounds like the same thing. And attempted murder. District court held exclusion of alibi witnesses. And again, this is in a trial, not in a pretrial. Exclusion of alibi witnesses without inquiry into prejudice. To state if defendant's alibi witnesses were permitted to testify where defense counsel violated notice of alibi rule. Failure to explore reasonable alternatives to exclusion remedy constitute reversible error. This is a trial. This is a post-conviction. It's completely different. And it's fine if you want to analogize, but no. Not only did the court not grant the defendant's request for a recess to allow interviews of the defense witness by by the state. It also failed to fashion. Don't say the court failed to do stuff. You try to give 1 day notice and then you're going to turn around and say the court failed. That's insane. It also failed to fashion another less severe sanction, such as continuing the hearing for the state to obtain the needed information. Comer versus... Yeah, I know, Cals. They've had 6 years. And they only have like 2 of them anyway. And we'll get to this in a second, but it being late notice for these witnesses in particular makes it even worse. Reversing where the trial court precluded a late listed defense witness from testifying without conducting a Richardson hearing. I don't know what that is. Or considering less severe sanctions. I'm positive that this is going to be a copy and paste, but we don't have time. Florida courts are clear that witness exclusion should be a last resort. You just cited this. There's a period here which tells me it's copy and pasted. Should be last resort reserved for extreme or aggravated circumstances. And they said that we know this is a trial. This is a criminal trial. The exclusion of the testimony of excluded witnesses was relevant and necessary for the court to make a discretionary bond determination. The way you keep sliding them... Calzo, the way you keep sliding them S's in stock is killing me. Yeah. I can't help myself. This is a self-diss. This is not... They played themselves, as some might say. If they're it's relevant and necessary to make a decision, and you didn't disclose them until the day before, that makes it worse. It's relevant and necessary, and you didn't know until the day before. Moreover, any detriment to the state was at least partly self-inflicted, since the 2 witnesses were disclosed 2 days prior to the hearing. Yet the state simply chose not to depose or even interview them, and refused to recess or bifurcate the hearing to do so. It was error excluding the witnesses. That's a bold claim to make. They didn't depose them in the 2 days between notice and the hearing, or 1 day, whatever it is. The court is afforded considerable latitude. I don't know why I selected this. The court is afforded considerable latitude in address situations such as the late disclosure of witnesses, but when considering the remedy for late discovery, the severe sanction of exclusion for the failure to timely comply with the rules should be a last resort. Didn't they just say this like verbatim up here? This looks like I'm a crazy person. Last resort and reserved for... You already said that. Okay. Particularly when the excluded testimony relates to critical issues or facts, and the testimony is not cumulative. This is definitely going to be a trial, isn't it? Crying over and over about the self-inflicted wound. It's... Exactly. It's like you're yelling... You know what it's like? It's like Dexter Bond. This motion is the Dexter Q Bond of motions. It's very loudly and arrogantly, ineffectively, and stupidly explaining its own failings, thinking that the tone is the substance. Also, it's a clown. I think it's this one. The court is afforded considerable latitude in addressing situations such as a late disclosure of witnesses, but when considering the appropriate remedy, the severe sanction Yeah, this is just from the head notes. This is just copied from the head notes. It's not even the case. Particularly when the excluded. Yeah, this is this is from the Westlaw head notes. That's bad. 196.3. Yeah, they're not giving a page number for their citation, so it's just a straight up copy from the head notes. That's really bad. Now they're not even like reading the case they're citing. The testimony of the agent of the security company. Okay, this is what I want to say. You're giving the identity of the security company the day before or 2 days before. So why would the judge think that there's been a lot of thought put into this security plan? You just found him a day ago. How much background checks and evaluation did you do? You found a guy yesterday. The security company would have provided relevant terms and conditions of the bond. The agent from the security company would give the terms and conditions? Oh, the testimony of the bond. Never mind. Okay, that it would. I thought I was wrong, and I was, and then I was right because they messed up a second time. Conditions of the bond that would be in place to protect the public from risk of harm. What is this? This is assure Mr. Demons. This just makes me sad. Assure the integrity of the judicial process. You're gonna have the security guard tell you about the assurances. That's the integrity of the judicial process. That guy sounds great. He should have written this, along with description of property and safety plan. Lovely. Dr. Holmes would have provided relevant testimony. Wow, this is bad. Okay, so this is the second witness, and she was there to provide detail as to the extreme, debilitating, and inhumane conditions that your client was suffering for over 3 years, and you got him yesterday. Well, it's great that you care so deeply about your client and their extreme, debilitating, and inhumane conditions that you got somebody yesterday, including how the Broward Sheriff's Office has and continues to violate contemporary standards of decency. Fair. And the unreasonable risk of serious harm to the health by forcing him to spend almost 24 hours a day. She would have attested to the fact Mr. Demons has no access to phone calls. Seems like actual ineffective assistance of brain. That's what it sounds like, Kat. It seems like ineffective assistance of neurons firing. I specifically didn't criticize her the first time. But this is just insane. And who is Dr. Holmes? Why would she have this information? Are you going to... Severe psychological strain. I have severe psychological strain and physical harm that Mr. Demons is being subjected at the... at the hands of Broward County has become even more pressing. Fantastic. It wasn't previously pressing. In light of recent order from the 4th DCA in case no 4D20240248, setting oral argument for September 16th. What does that mean? I don't know what any of this is. I don't know what the recent order is. I don't know what the appellate issue is. I don't know what the case is. And I don't know... Oh, I'm stupid. Nope, I know what this is. That's the appeal in this case. I don't know why it's relevant, but I do know what that is. Despite the I did a cat's factualizes. I did a cat's eye. Cat's eye. Despite the court being adamant that trial, this is bold. I was at Christmas, and there's a small child. He's like 3 years old, and I was trying to get it. It was like getting towards the end of the night, and he was playing in the sand, and he was taking it over to this like turf grass, and just dumping the dirt onto the fake grass and making piles. And I told him to stop, and he did it again, and he dumped another pile while looking straight at me in the eyes. And he slowly dumped that bitch just straight onto the grass. And he didn't just want to disobey me, he wanted to know. Cat, you almost got me there. He wanted me to know that he was disrespecting me while he was disobeying me. It wasn't that he wasn't listening to me. He was listening to me, and he was disrespecting me while he did it. That's what this is. You're terrible at everything. And then you say, despite the court being adamant that trial will begin September 6th, the reality is a retrial in this matter will not occur until 2026. You're just calling the judge a stupid bitch after you just spent pages acting like a jackass. One day, he ran about the Supreme Court of New York being the trial court. It doesn't even stop there. It just gets stupider. There's like an appellate court that's called the Supreme Court or something like that. And also the Yankees are there. Yeah, this is insane. You just don't say that the judge is unaware of reality. That's the general rule, unless, we really want to. The cost to house Mr. Demons, including the special conditions. Made for him by BSO, along with the cost of this prosecution, is estimated to be in the millions. Not only would the above proposed conditions protect the community, it would save the citizens of Florida money. Yeah, Trin. Yeah. I realized that after a second. I forgot about that. I think I have some documents on from that. Not only would the above conditions protect, it would save money, because Mr. Demons, not the state of Florida, would pay costs of GPS location. The order fails to make findings of fact regarding conditions of release. Okay, the improper exclusion deprived him of his 6th and 14th Amendment rights. Ooh, I didn't see that, Trin. I didn't see that one. Trin said, order that appellee's cross-reply brief is stricken. Who's the appellee? It's Florida, right? The apply relief? Oh, cross-reply. They're cross-appealing. Oh my god. I can't remember which one it is. Exceeding the word count's not excusable. I didn't find it. I need to check those briefs. December. Okay. The improper exclusion. Yeah, 6th and 14th. He was deprived of his 6th Amendment rights. The Supreme Court elucidated. Don't just use elucidated out of, like, you haven't been struggling to put words together the whole time. Whether there's a reasonable probability that the lack of evidence complained of might have contributed to the verdict. Though there was no verdict. It's from 1967. Granted the motion for rehearing, conduct the appropriate hearing, establish time frame for the state to depose defendant. Witnesses. Second motion. Oh yeah, I can do that, Callus intern. I forgot about those, actually. September 16th, that's the day before my birthday. Maybe I'll go party in Miami and then, in the form of appellate hearings. Any other relief this court deems necessary and just. I wouldn't say that. I wouldn't ask the court to do whatever it deems necessary. Yeah, no, for sure, Trenton. I think, I know I downloaded them. I completely forgot about this. The appellate briefings. Any other relief this court deems necessary. I hope for that too. No, you did not. No, I didn't even notice this. That is insane. And then they leave the page with nothing on it because, why not? So that is one. And it doesn't get better. Let's see if we can do another one. Where is my folder? There it is. This one was... Ooh, I hope this doesn't have anything... Okay, good. I did delete all the comments on it. Let's see. I don't know what this is. This is 5-7. So this was right before the... was it the hearing or was it the... I think it was right after the hearing. Before or after? I need a new rabbit hole. I've been in Karen Reed's hole. I really struggled to get into Karen Reed this time. Yep, I said that. Yeah, it just wasn't that interesting to me this time around. I know. Thanks, Kat. Yeah, that was a phrasing situation. Are these different fonts? Anyway. Yeah, so we're going to get stupid. We're going to get really stupid here. Notice of serving case law in support of pretrial release. Comes now the defendant. This needs to stop. I don't know what this is. Every state that does this, stop. By and through the undersigned attorney and gives notice of serving the below case law. But why, though? Why are you doing this? This is Florida versus Arthur, which he's heard 9,000 times in the last... in the last motion. So let's see if we can find it here. Oh, here we go. Have it open. See, it says establishes trial court has discretion to grant bail. Where a person accused of capital offense or offense punishable by life seeks release on bail. Okay. I know this is taken somewhere. Establishes trial court. Discretion. Okay, this one I'm not going to complain about. This is actually okay. It's not okay, though, because, so when I first started being a lawyer, I didn't know everything like I do now. And my boss, who's like an academic, he had a PhD first, he said before a judge reads a briefing or whatever kind of filing it is, they're going to look at it, and if it just looks stupid, they're not going to take you seriously. This looks stupid. It looks wrong. It is, but it also looks wrong. I used to do drugs. I do now, but I used to too. And so he said format, especially like the cover of documents, the caption is really important because judges won't take you seriously if judges won't take you seriously if it just doesn't look like it's done correctly. And like this is nitpicky, but like so are judges. Not all of them, but many of them. There's an extra underlining the blank space. There's no comma. There's an extra space here. You have periods here, but not here. This is lowercase, uppercase, no period. This is the same citation, but one has a period and one doesn't. And you're doing periods but not app, but you are doing the other three. Let me see. You're doing state of Florida, and then you're switching to state. There are no commas at all here. It's just, it's not ideal to do things this badly. Usually you want to do things well, and they did things badly. Okay, let's see what this says. Established trial court has discretion to grant bail to a defendant who's charged with a capital offense. Okay, that's fine. Russell versus State. Defined the word evident. This doesn't help. Okay. As clear to the understanding and satisfactory to the judgment. Its synonyms are manifest, clear, plain, obvious, conclusive. The word manifest is defined as put beyond question of doubt. What you're doing with this is just making it really clear. Actually, no, this isn't that bad. I get what they're saying. They're saying that the state has a high burden and it needs to be clearly met, and they're emphasizing that, but they're not actually making an argument. I don't know why they're telling me this. I mean, first of all, the judge is going to know this. They're going to know this. Like, why are you sharing this? What is the argument you're making? Yes. Another story about this boss. He's the only one I've ever had. He liked very academic writing, very like fancy writing. And there were times where I'd turn stuff in, and he would call me into his office and say, "Look, I'm not like it's legally it's perfectly correct, but it's just kind of boring. Can you like spice it up a little?" I've never had that happen with any other person in law. They usually care about the correctness part. But he wanted judges to be, to look forward to our filings. But that is frustrating. Let's see. Seymour versus State. Holding the degree of proof greater than that required to establish beyond a reasonable doubt. I don't know what that means. Holding the degree of proof greater than that required to establish beyond a reasonable doubt. I don't know. I can't even comment on that one. Let's look at Reeves. The next one here. Establish the trial court has discretion to authorize pretrial release. Here we go. Trial court discretion to authorize pretrial release per defendant. Even though state established that defendants, I think it's this one. even though state established defendant had no constitutional entitlement to pretrial release because proof of guilt was evidence. Defendant was not a flight risk, and there was no argument. Non-argument? The detention was needed to assure the integrity of the judicial process. And trial court outlines conditions for release. Yeah, this is just a complete quote. Is he coming out? Am I coming out? Perhaps. Yeah. So this is just a verbatim quote from a Westlaw head note. So it's not even a quote from a case. It's just went to the head notes. You don't even have to get to the text of the case. You're just cutting verbatim from the Westlaw head notes. They're trying to kill her client. That's not the level of care I would like. Everybody gets bond. Happy birthday. That was a funny comment. So yeah, that didn't involve any work or research or reading, really. Third one, Seymour versus State holding. Let's say holding the degree of proof. Let's see, holding the degree of proof. This one's probably okay. I don't know what it means, but it's okay. So yeah, there's just this hurts. This doesn't help. Like it's purportedly in support of pretrial release, but it's just this disjointed mess. One more at least. Let me see if I did anything. Okay, good. I didn't leave any comments in there. This was a little bit, actually might have been the day before. A different, 2 days before. Where was I? Remember to like the stream because I know. The first several streams, like stream because Hal doesn't remember to ask. Only like my first many streams, Kat had to like, she had to be the one to tweet that I was live because I forgot. That was helpful. That helps actually, is tweeting that you're telling people that you're live when you're live. I know that's counterintuitive, but it is. This one is dumb. It's dumb. So this guy, John Phillips, who I think is on Court TV or something, he was tweeting with some people, and he tweeted out autopsy photos that were supposed to be, I don't know, under, what's it called? Seal? And so they were unhappy about that because it's gross, but also maybe illegal. So that is the context. Urgent motion for an order to show cause against the office of Broward State Attorney Harold Pryor and John Phillips. Esquire. Yep, no, I'm not even doing this time. We're starting right here. This doesn't exist. The office of Broward State Attorney Harold Pryor and John Phillips, Esquire, both members of the Florida Bar, should be referred for disciplinary action due to conduct prejudicial to the administration of justice. Support thereof, the defendant asserts the following. Under seal. Kissed by a rose. Oh god, I just got triggered already. I forgot how bad this was. On or about November 2024, the office of Broward State Attorney Harold F. Pryor. What even is that? Is this a full name? Is it like a Tribe Called Quest? You see the whole thing? Authored in order at the behest of Attorney John Phillips Esquire. You can just say John Phillips. Providing in unredacted form. Right here. Evidence demanded. Wait. They authored an order that provided evidence. I think they meant an order that would provide for the provision of evidence. See copy of email, including proposed order attached hereto as Exhibit 1 and made part of this motion through this reference. That's how you do that. So we're going to skip number 2. We don't need number 2. I can't. The Office of the Broward State Attorneys. Okay, so this is a different one. It was the Office of Broward State Attorney Harold F. Pryor. Now it's the Office of the Broward State Attorneys. Agree to provide all the unredacted evidence to the decedent's attorneys without informing this court or the defendant's criminal attorneys. Okay. Do they need to do that? The records demanded included but were not limited to unredacted autopsy photographs of the decedents. That's messed up. Photograph or video or audio recordings of an autopsy held by a medical examiner. Yeah, I can do either actually. And exempt from these sections there about how I looked this up once. How autopsy photos are not subject. They're both maintained in our public record, but they're not subject to open records requests. But that says with exception to surviving parents. And as far as I know, Phillips does actually represent one of the families. Okay, it was discovered. This is passive voice fuckery. Who discovered it? It was discovered on or around May 3rd. Attorney John Phillips released various autopsy photos of Christopher Thomas on his X account while engaging in analysis and arguments for the public. That's messed up. Don't do that. Oh, wait, I missed this one. I knew it was here somewhere. John Phillips et al. That's another one. John Phillips. Yeah, this is weird, but John Phillips does not represent the interests of Christopher Thomas, and he nor his clients were not entitled. Neither he nor his clients were entitled to the privileged autopsy report or photos of Mr. Thomas. But is that because he asked for them and then he was given them? So even if he's not entitled to them, he still has them, and he got them legitimately from the government agency from the prosecutor's office. So that one might not even be relevant. Oh god, this guy's so terrible. Yeah, he was showing autopsy pictures on Twitter. John Phillips is causing significant public dissemination of sensitive material that he should have never been allowed access to, but for the Office of the State Attorney. See, now we have another one. It's the Office of the State Attorney. What do we had so far? And what is that? There's so much space down here. Office of Broward State Attorney. Office of the Broward State Attorneys. Oh, I forgot one of my favorite things. So it goes 4, 5, 6. And then this is 1. Ah, no. And then we do 6 again. But I guess if you get rid of this one, and you get rid of 2, then this one is actually, this is correct. So that's okay. And also, John Phillips is not causing the dissemination because he equals public. That's not fair. You can say he's causing dissemination. What you can't say is that his name is John Phillips now, because you're just calling him Attorney John Phillips Esquire and John Phillips et al. Fucking John Phillips. Criminal charges related to the photographs are still pending, and the unauthorized release has potential to severely impact the integrity of the proceedings. The conduct of the Broward State Attorney's Office is another one, and John Phillips together actually, no, that is right. Constitute a violation of the ethical standards set forth in the rules. Footprint 8.4 prohibits conduct that is prejudicial. Okay. The unauthorized dissemination of sensitive autopsy photographs undermines public confidence in the legal system. How? How? And what does the rule say? Exactly. The Florida Supreme Court has addressed similar ethical breaches, including but not limited to prohibiting a lawyer from engaging in conduct in connection with the practice of law that was prejudicial to the administration of justice. That makes sense. I probably want to be a little more specific than that. So let's see this case. I don't think it would be possible to state that any less specifically. Supreme Court has addressed similar breaches, not limited, prohibiting a lawyer from engaging in conduct that was prejudicial to the administration of justice. Let's see what that case was about. Disciplinary proceeding was brought against attorney for having undisclosed personal communication with presiding judge in capital murder case in which attorney was the lead prosecutor. That's a little bit different. When you're prosecuting a murder case and talking to the judge, that's different than when you're prosecuting a murder case and giving photos that end up on Twitter. Because Twitter and the judge have different roles to play in murder prosecutions, especially in capital crimes. See, the judge oversees the proceedings and Twitter just, precipitates the fall of man, that sort of thing. So let's see that one more time. The Florida Supreme Court has addressed similar ethical breaches. So they're saying that talking to the judge in a capital murder case that you are in which you're the prosecutor is similar to giving somebody pictures that get posted on Twitter by a lawyer who's arguing with randoms. You know what? Having argued with people on Twitter, I get it. No, I don't. I'm just kidding. That's terrible. Don't do that. So that's an insane comparison to make. Let's see what this says. Florida Bar filed a complaint against attorney alleging various instances of misconduct relating to his representation of client divorce proceedings. Referee recommended that attorney be suspended for 60 days. Okay. Instance, that's not relevant. Attorney violated rule prohibiting knowingly disobeying obligation under rules of tribunal. Violated rules for making frivolous discovery requests. This is within the context of proceeding, not a pretrial discovery communication between a party and civil proceeding in the state and a criminal proceeding. So that's completely different. So that's all. They're all completely different. The Florida courts are clear that the public is to be protected from unethical conduct. Yes, and unethical conduct has to be sanctioned. Deter other lawyers from engaging in similar misconduct. I'm just getting sad. I don't even want to keep doing this. I want to talk about something else now. I can do this, I can make fun of people for a long time, but this is just, it's so insubstantial. Florida Bar filed complaint, professional misconduct. Did I just copy and paste the same thing? No, I didn't. This is a different one. It's funny. Violations, 90 days. Violated rules of professional conduct. Okay, evidence supported finding that attorney knowingly filed dissolution client's inaccurate financial affidavit and failed to disclose existence of cashier's check belonging to client. In violation of rules of professional conduct, prohibiting unlawful and dishonest acts. That's bad and different because it's financial crime. It's not giving somebody pictures. The duty to protect the public. This one, okay. Paramount means the highest. The duty to protect the public and maintain the integrity of the legal system is paramount. By protecting, it's been 6 years. Constitutional right to a fair trial is greater. The actions of Broward State Attorney's Office. We have another one. Agreeing to provide. So the action is the agreement. I think it's the provision is the problem. By the unredacted evidence to a civil attorney previously known to continuously post about the criminal case. True, though. That's fair. Has not only compromised it's just conclusory. How? How has it done this? The action of John Phillips. Done with malicious intent. Twitter, they deserve malicious intent. Those people, malice is appropriate. Have not only compromised the ongoing criminal proceedings, but have eroded public trust in the legal profession. Did she just... See, I read this roughly when it came out. I haven't looked at it in a while. I forgot some of this stuff. It's the same... They're two conclusory statements, but they're the same ones. This sounds like a Game of Thrones, some Game of Thrones shit. The Office of the State Attorney, which is... The usurper. The Office of the State Attorney has been caught again usurping justice. You got to be dramatic if you're going to use the word usurp. The Office of this... You know what I'm going to say that. The DA ever emboldened by their increasing by the court's unwillingness to impose meaningful sanctions have ceased control of the judicial process and Nearly. The judicial process. This is how you do it. You don't just use usurpation if you're gonna. This attorney emboldened by the courts. I wouldn't say courts, but no, I lost it, and it's gone. I wouldn't say that. I spent all that time and nothing. My point is, if you're gonna say usurp, you have to, you can't be milquetoast with usurp. Make it sound cool. This time around, they're conspiring with the decedent's attorney. They're not conspiring. They're negotiating. John Phillips to sway public opinion and taint the jury pool, thereby precluding Jamal Demons from receiving a fair trial. The misconduct of the office. The misconduct of the office Broward state attorney. They didn't even accuse Pryor of doing anything. I don't know who he is. The DA probably is not only willful and flagrant, but it is ongoing and compounded with one intentional ethical violation after the next. You only named one. The conduct of both the office of the state attorney and John Phillips must be stopped before other prosecutors and or attorneys. What the fuck are you talking? What is any of that? Office Broward State Attorney. A lawyer deserves to be sanctioned. They're definitely right. The conduct of both Office Broward Attorney Pryor Harold, Phillips John. The conduct of both the Office of the State Attorney and John Phillips must be stopped for other prosecutors and or attorneys. Maybe they mean before, as in like before visibly, like to humiliate yourself before the rest of the legal world. This is so unacceptable. Everything in Florida is unacceptable. The tweeting's bad. Office Broward is bad. This is ridiculous. Why issue an order to show cause? Why the office should not be referred to the bar. Okay, I wouldn't hate that, but it's not for Melly to ask for that. Disqualify John. What is et al? You can't ask for a disqualification et al. Unless there's somebody named et al. There's somebody named Al. No, you're going to need to name names. Any further representation of the decedent's family in the subject matter criminal proceedings. I think they mean civil? No, they mean criminal. They're talking about the appearances. Any other relief this court deems necessary. Again, be careful with this, because certificate of service. What is this? Why is it? Why is it not bold the whole way? Exhibit 1. Why? No. Nope. This needs to be down, all the way down here. John Phillips. Subject, Demons. I don't read clearance. I'm not defending John Phillips. I'm not... How can I say this? He sucks. Yeah, that's how I'd say it. Judge Lynch, you described the discovery file. They wanted to bind us to... So they were contacting a magistrate, like the judge overseeing the proceeding. So they did... They did contact the judge. There's the administrative judge. There's the magistrate. Right? Without informing... That's funny. Without involving this court. Did they say... Never mind. I thought I had something. But yeah, they did requests. They were communicating with the judge. Judge Talman, yeah, the mediator. They're in mediation between the prosecutor's office and... Wait a minute, the DA isn't even on this email. These are two civil lawyers contacting the magistrate. What does the DA's office have to do with this? That's bad. Okay, that's stupid. And then we have nothing in particular. It's just making me sad. I'm gonna see if I want to read this or if it's just gonna... Oh, man. I think I need to do this. I don't want to, but I feel morally obligated to do this one. This is the actual motion for bond, the bond motion, that I've, they lost because they didn't try to win. They didn't say comes now. That's good. Oh my goodness, okay. So in this one, they're asking, the last one we read, they were saying that, that's a problem, that they were proceeding under either Arnold or this one. They didn't mention that here, so they weren't actually proceeding under Arnold. Set a bond. Mr. Demons voluntarily surrendered on February 13th, resulting from a grand jury indictment. In terms of a result from follow. Charge Mr. Demons to counts of homicide. A written demand for speedy trial May 26th, and jury selection was to begin in the middle of July. Trial did not occur as demanded due to the state appealing an order of the court striking the state's request for imposition of the death penalty upon conviction. Okay, don't say it did not occur as demanded. Say his rights. I don't know. Say something that his rights were violated, or they say compromised. Due to, as the state, for the first time, oh my goodness, forced Mr. Demons to wait while they pursued his death. Be dramatic, it's fun. Be a little messy. Okay. The trial did not occur as demanded. But why? What's the point? Okay. Request for institution death penalty upon conviction. The DCA reversed. Supreme Court declined jurisdiction. On April 6th, the undersigned filed a notice of expiration of speedy demand. A hearing was held, and jury selection began hours later. Opening arguments were given on June 14th. This will make me happy. Okay. July 22nd, Judge Murphy declared a mistrial wherein the death qualified jury was unable to reach a unanimous verdict as to Mr. Dan's guilt on all counts, and set their retrial to begin being. I just saw this while I was scrolling looking for something good. Cool. Welcome. I was really having a good time when I started reading these, and then they're just so bad that it almost became depressing. Because they're really bad. But yeah, I'm with the first part of the very first motion for bond release in Melly's case. I don't know if you're familiar with the case, but I kind of worked backwards on this one. So if you like this, yeah, go back and look at the start too. On October 12th, then lead prosecutor Christina Bradley was removed after the defense team learned of an all office conspiracy to withhold Brady evidence. Detective Mark Moretti asking another officer to lie on his behalf. You gotta be dramatic. Continuing a pattern of misconduct. The state conspired to fuck around. They found out, right, upon the disqualification of Ms. Bradley, for once, they found out. There you go. As a result, 3 new prosecutors took over the matter. The court... I kind of started that one out seriously, and then I just didn't finish it. But I mean, the point is, they make it sound so sterile. Well, be mad. You're advocating. Be outraged. If it's outrageous behavior, be outraged. As a result, 3 new prosecutors took over the matter. The court granted the state's request to extend speedy trial due to extraordinary circumstances. No. No. Due to the state needing time to recover from the disqualification of their lead prosecutor for egregious and unforgivable lapses in professional, I don't know, lapses in ethical judgment. I have made a severe and continuous. Okay. Yeah, this is be angry. The parties began selecting a jury on or about October 25th. I wish you knew what day it was. Jury selection was only set on the days that ASA That's not her name. Bucklew was available. Oh, man. You're glad that ASA schedule was not. Alright. ASA was not dissatisfied while defendant rotted in jail. The bifurcated process was not successful due to the parties sometimes only convening once a week. I don't know what that means. On or about December 14th, the state gave notice of their intention to introduce the entirety of Mr. I swear to God, if they don't stop doing that. Oh, this is A+ content here. Mr. Demons' music catalog and hundreds of hours of jail phone calls of other inmates, along with YouTube videos of 1099 Jake. I don't know if that's a 1099 miss or a different kind of 1099. Honestly, I'm fine with that one. I have no complaints. 1099 Jake is appropriate. December 20th, based on the prospective introduction of... No, I take that back. You gotta make fun of this, too. On or about December 14th, 2023, apparently discovering for the first time the internet and the existence of Genius.com, the state gave notice of their intention to introduce literally every lyric ever rapped in any song by Mr. Demons, as well as hundreds of hours of jail phone calls from people who are not Mr. Demons, and along with 2 YouTube videos of the worst person on the internet. On December 20th, based on the prospective introduction of new evidence, while selecting the jury to Mr. Demons' detriment, it was decided that the entire jury panel would be struck. Then you do a new paragraph and you say, Mr. Demons continued to rot. To rot as his 20s neared their midpoint, all of which were spent in jail. The defense team was forced to withdraw the speedy demand in the homicide matter and seek a continuance. No. You say forced to compromise at least one of his constitutional rights, or forced to sacrifice at least one of his constitutional rights. Defendant chose to withdraw the speedy demand. You know, why do these things matter? Why, in isolation, why does this paragraph matter? The defense team is forced to withdraw the speedy demand. You're asking for the bond to be granted. So you're talking about constitutional. It is 1090 Jake. That's right. There's no 1099 Jake. Well, I guess there is now. But yeah, they're not. This isn't an argument for a bond. They're just talking about justifiably about why the DA's office sucks, but make an argument. So, forced to withdraw speedy demand and seek continuance is agreed. Parties will begin selecting a jury beginning January 24. It has now been discovered. Stop saying that. By whom? Who discovered it? In the midst of all the delay tax by the state's attorney's office, this is a... Oops. This is one sentence. December 13th, the warrant was issued pertaining to multiple telephone numbers of the undersigned. Don't do that. Just say who it is. including cell phones and landlines. That is all of the telephone numbers. Searching for information regarding Danny Polo and a YouTube content creator who goes by 1099 Jake. It's still funny. I'm still fine with that. So what? Why does this relate? Say, exploiting the delay violative of Mr. Demons' rights. The DA then you go to it. Make it clear that the delay is the issue. I mean, it's not that there's a warrant. In fact, that they've exploited the delay, and that the state has had plenty of time, and they just chose to spend it on misconduct rather than, conduct. January 13th, the state appealed certain orders suppressing evidence regarding email, social media, and texts that were prior to the date of the alleged offense. Again, so what? What does this have to do with bond? January 29th, the court entered an order staying the trial. An order was entered stating Mr. Demons was in custody. Again, why does this matter? An order was entered stating he was in custody for 1,977 days and his retrial was set for September 10th. I mean, upon information and belief, it is very unlikely this matter will be ready to go to trial. Defendant now remain incarcerated for more than 2,000 days. Mr. Demons, for several years, been the subject of extreme mental abuse at the hands of Broward Sheriff's Office. Okay. He's not had any contact with the outside world in 3 years. Mr. Demons remains, to this day, a lucrative recording artist with streams of incomes. He cannot contact his managers or accountants. As a result, he has lost any control over anything he has. I wouldn't have just stuck in the middle there that he's got racks on racks on racks. You can't be like he's rich as fuck and he doesn't even know it. Don't do that. Like, if you're gonna do it, say money is made off of his name while he sits isolated from the world, unable to monitor the purported wealth as people to whom he can't even speak. I don't know, receive the benefit of his labor or something like that. I don't know. I mean, don't just say he's got a ton of money with multiple streams of income. Explain it. Mr. Demons is not allowed to talk to his younger brother or sister. Shut up, B-Slime. Mr. Demons has protected and supported both of his siblings throughout their entire lives. Don't say he's protecting people. That sounds like he's fighting for them. And it's a murder trial. And their mom comes to trial all the time. You can say Mr. Demons has helped raise his younger siblings and along with his mother, blah, blah, blah. Mr. Demons is not allowed to speak to other inmates in the jail, and over a week ago, a sheet was put over his cell door so no other inmates can look at him when they walk by. You gotta if they're using a bed sheet to cover stuff up, there's a joke there that you have to make. Having litigated several motions in the trial court. It's so boring. Mr. Demons continues to defend his constitutional... Why would you say that? You're saying that he hasn't been able to defend them. Ooh. Hey. Okay. Perseverable, not punishing accused. Nor, my dog just tried to run outside. No detaining accused in custody. The purpose of bail is not to detain. Yeah, okay. Purpose of bail is to ensure an accused's appearance in court. That's a great name. The constitutional right to pretrial release guaranteed to a person charged with capital offense or an offense. This isn't even true. You don't have a constitutional right to pretrial release, governed by well-established precedent of the Florida Supreme Court, State v. Arthur, as recently explained by 3rd DCA. By way of background, you don't need this. The Florida Constitution gives a person arrested for a crime the right to pretrial release. Yeah, this is the subject to certain exceptions part. The capital or life offense exception applies when the person is charged with a crime punishable by. Oh my goodness. The capital or life offense exception applies when they're punished by capital or life. If they can demonstrate the proof of guilt is evidence. Yes, a person held under this exception is entitled to an adversarial evidentiary bond hearing. Examines the state's that nobody disputes this. This is not in dispute. You know it's possible. Accordingly, a defendant charged with a capital crime entitled to a hearing. Again, we know he's entitled to a hearing. The long-standing precedent recognizes that the requisite degree of proof is higher than that of the degree of proof necessary to sustain conviction at trial. This is actually, we're getting there. Saying there's a hung jury, so you can't possibly have a higher than, a reasonable doubt. Even state was to meet its arduous burden. Arduous burden? No. Proving that the proof of guilt is evident and the great trial court's not precluded. That's determined from ordering the release upon reasonable conditions. Rather, the trial court still has the discretion. This is just a repeat of what was set up here. It's essentially the same thing as this. And this. I'm just repeating myself again. The burden is on the accused to demonstrate that release is appropriate, which has been established even if Demons has no right. The defendant still has the option of proving certain facts. I think I read this earlier. That permits the circuit court to use its discretion. Is that why it's in, where was this? Maybe not. Circuit court may exercise discretion to grant release if the defendant can prove that conditions of release can effectively protect the public from harm, assure its presence, ensure the integrity of the judicial process. Appropriateness. It's not permissible to continue to deny which demonstrates the fundamental right to liberty. This. You got to come up swinging a little harder than that. It's not that they've just denied him the right, they've denied him liberty. It sounds like they've specifically the right to a speedy trial. Or you could argue, effective assistance or cruel and unusual. It's sort of the aggregate violation of rights in addition to, the ongoing right, or the ongoing deprivation of liberty. Mr. Demons voluntarily surrendered. I'm pretty sure they said this already. Yes, they did. They said that exact paragraph. Oh, man. Mistrial was, let me see. Voluntary surrendered. He survived COVID. Filed a trial in May of 23. Mistrial was granted with genuine hopes. No. Let's say it was obligated. Don't talk about hopes. Expect rights. Started a retrial in October. That date did not occur. That date, October 23, did occur. The lead prosecutor withheld evidence. Like, this is bad, but make it matter. Same here. So what? Why should I care? Why is it relevant? There appears to be no insight for Mr. Devins. The case has been stayed for more than a year while the defendant has remained held in unduly strict custody, being abused at the... This is the stuff you need to actually talk about. And then tie it into the general theme. There are multiple other motions solemnity heard. The state takes an appeal every time they're not successful, as they've done on multiple occasions in the past. Then Mr. Demons will sit in jail for an unknown period of time before the case can possibly be tried. Being forced. This is a great argument. This is the entire point. Are y'all cool? Is y'all cool? Sorry, I've always wanted to say that. Oh, man. Let me see. But yeah, that's the entire point. He's a good boy. He's just very excited. If he's very high energy, he barks, and if he's very low energy, he barks, but sometimes if he's just energy, he barks. Not only is the amount of time Mr. Dunn has been in Broward unconstitutional, it's not. Coupled with mental abuse, deprivation, basic human rights, the entirety of the situation is an embarrassment. Horrible reflection of the entire legal system in the state of Florida. I wouldn't worry about that. Come on. You guys wrestling gators. It's not a problem. This is not... It doesn't have much to fall. Let's say, unlike the reputation of Florida man, Melly has much to lose. At this very time, BSO has placed a sheet to cover Mr. Devon's cell, so another inmate can contact him. Oh, he's eating now. This abuse has gone on for over 3 years, and when any attempts are made to rectify the deprivation, the defense is always met with "there is an investigation." You gotta say something like, "We understand that it's in their blood to hide their abuses of civil rights under a sheet, but no more." And you make fun of them. In the past, everybody needed their own bed sheet to hide the abuses, but now just one will suffice. You don't have to be subtle with it. There is no reason to believe that the defendant poses a danger to the community or risk of flight in this cause. As such, there is a presumption in favor of that defendant. I don't even want to correct that. There is a presumption in favor that defendant should be released on his own recognizance without the need to post any financial bond. That means the same thing. To that end, certain conditions can be set by this court to ensure defendant's appearance at any required court dates. Okay, what are they, though? Wherefore, defendant demands respectfully request this court grant the instant motion and order defendant released on his own recognizance. I think they're requesting a hearing. Are they not? Okay. Okay. This just... I want to show one thing real quick. Let's see. Oh, whoa, that didn't work. I haven't used this in a while. You guys hear me okay? Hold on, that wasn't what I was looking for. Let me see if I can find it. Is this it? Huh. Wait. Maybe that's it. No, that's not right. Maybe this is it. No, this can't exist. This plea hearing didn't happen. Adrian Love didn't take Moon Thung's guilty plea in 2017. That would have been disclosed. That can't be right. What am I looking for? See, now I was joking, and now I can't remember what I actually was looking for. That backfired on me. Oh, right, I remember what I was going to do. So, that's the problem I have. They're not arguing for a bond, and you can watch the bond hearing. They don't make a case. They said they got it in a single line. It was frustrating that they didn't go into it in more detail. This. I'm going to cut it real quick. My goodness. It was Mr. Demons being forced to choose between a fair trial, a speedy trial. So that's a good argument. Let's say it's been, 6 years? I think it's almost 7 years The state has had its chance. State spent time engaging in misconduct and now asks Mr. Demons to wait. Mr. Demons is already deprived of a already been deprived of his right to a speedy trial. And he has already been subjected to a trial tainted by misconduct. Mr. Demons' rights have already been lost. The only question is which rights will continue to be violated. And which rights will continue to be violated and to what extent. Mr. M is being forced to choose between having his first fair trial wait, not wait. What? What's the... Oh man, why is my thing all the way over? What's the what lady? The what lady sings? Third line? To what? I look at it. I always want to go there. It's a little face. Look at that. It's a cute guy. Look at that little guy. Oh, I got his nose. Oh, sorry, I just lost it in my mind there for a second. Already lost. That's true. Another question here, which rights will be violated and what extent? Demons is forced to choose between another run for a trial. And an offer. Or years of unlawful detention and in hopes of a fair trial. Something like that. It doesn't have to be perfect, but you know. And then like you can get into the procedure stuff, that's fine, but there's no what's the argument? What are they're not making an argument. And Danny Polo's on the other side. Just I would put a picture of Danny Polo in the corner of every page. with a little arrow pointing to him and say that this is why. This person in this shiesty. It'll make him sad if you do this, so do it. Man, I totally depressed myself over reading this stuff. On a show. One more crazy little thing. And then I'll be done. This is on a different topic. This is a guy named Devin Grant. He got sentenced to life. I suspect that it may not have been on the up and up. And I'm not going to go into the full thing right now. But I want to show something that I didn't enjoy. Roy Blackstock is a name I do enjoy. We're not going to get into the fact that somebody else confessed to the crime and that the person was charged with a second homicide and had 2 teardrop tattoos and said that the other tattoo was for killing this person to his girlfriend. That's not a big deal. So, it's deliberation time. End of a murder trial. And this is what happens. In the case of Barr, the jury sent a request to rehear witness testimony. When jury sent a question during deliberation, there are certain requirements that have to be met by the trial court in responding to the communications. The court set forth specific requirements for a trial court when a jury wants to communicate with the court during deliberations. These communications must be in writing. The communication should be marked by the trial court. A court's exhibit. Counsel should be advised of the communications. Trial counsel should be given a full opportunity to suggest an appropriate response, and the court should advise counsel of its intended response before the jury is brought back so that counsel can suggest any modifications to the court's plan. That's not really the thrust of it, though. The trial court did not comply with the requirements for jury communications. The requirement that the communications must be in writing may have been complied with, but there are no exhibits. The trial court actually states, now they have asked for somebody else, and so the answer is no. It's 4:15, and I'm not going to go into no more. I said no more. I was thinking of Judge Glanville saying, or Yak said, Judge Glanville was quoting Yak, I want to talk to a lawyer, I don't want to talk no more, as I was reading that. One of Glanville's finest moments. Oh, Love got so mad. It was so wonderful. I'm not going to go into more. That's 4:15, the judge says. They want Scott Harrell's testimony too. I'm not doing it. I'm not opening it back up. They're just going to have to remember it. They can't forget it. They have to remember it. I mean, we can piecemeal this thing until we go back over the entire trial. I'm not doing it. I don't even mind sometimes doing two, but I refuse to go back over all this stuff again. Trial court did not allow for the replay of the testimony because she stated, it's Friday afternoon. I'm not doing it. It's actually 4:15 on Friday afternoon right now. That is a thing that I planned. I planned that out exactly for this exact reason. It's 4:14, but for me, the court did not have the... We'll see. Go down here. The record shows when the court declined to let them rehear the testimony, the jury reached a verdict 20 minutes later. The trial court said, I'll give them 30 more minutes. They want 30 minutes. That probably did it. I know, it's still 4:14 for me. That's terrible. That was so close. So yeah, the two people that the jury wanted to question is Talia Thomas, who supposedly heard a confession. She did not, and Harold, who I can't remember he's a witness. He was. You'll have to trust me, but picking these two witnesses was very clearly. It was hearing them would have helped the defendant. And the conviction was affirmed. Then, and don't worry about how I have these things. Where are they? Where did I put this? Okay, let's use this. Nope. I don't need to worry about any of this. This was its habeas petition. I need to see. This is 2014 Supreme Court case. Or it's just direct appeal, the new trial. Jackie Johnson was the DA. She handled the appeal, and there was a Batson challenge by the appellant. Jackie Johnson wants you to know that's ridiculous. She would never be involved in something inappropriate. She clearly respect her role as a prosecutor. Anyway, this is May 19th, 2022. The judge who presided at the evidentiary hearing on May 6, 2015. Now, I didn't notice this the first time because they were both May, but there's actually a big difference because this 2015 and this is 2022. See, 7 years had elapsed. And the reason is because the judge who heard the case was a retired judge. And he was old. He was extremely old. And he just never ruled. And he's actually dead now. And the rule says the habeas judge who hears the case has to be the one to decide it. And it has to be done within 5 years. So the wrong guy, I guess, didn't do anything. But yeah, there's a different warden, different commissioner. Please hope I don't have any more comments on here. And he waited 7 years. And he was checking in with the clerk's office the entire time. And they kept telling him there's no news. And then one day, this decision is handed down by the chief judge, Dwayne Gillis, prepared by the DA's office, or the AG's office, in 2022. I have no idea if any of them have even, I'm almost certain none of them are at the hearing. I can't get into the Brady thing right now because I'm going to punch a wall. Thanks, Vanessa. It's late there, isn't it? Was it 9 hours? Yeah, I like putting stuff out. I've been meaning to do it more. I'm going to try to do it on a more regular schedule. Like on Monday, Wednesday, Friday, or something like that. Because I have a million things to cover. Yeah. This particular one bothers me. Ground 3A, petitioner alleges he received ineffective assistance of counsel. Failing to have DNA testing performed on a red cup, the solo cup. I know Kat says everything makes her think of Karen Reed. This one might too. Red solo cup. The remaining claim, the ground, truck cup, whatever. 1220? Oh, 8 hours, okay. Some of the crime scene photographs did show that there was a red cup. Appellate counsel's review of the discovery revealed that there was never any DNA testing performed on the cup, but there's nothing in the record about an interview where someone stated that the shooter was drinking out of a red cup. You can't see this. Don't worry about where I got this. Appellate counsel went to visit petitioner. Petitioner never mentioned a red cup or any requests for DNA testing in their discussions. The Strickland standard. Petitioner's failed to show that appellate counsel performed deficiently. Counsel not have the cup tested. Appellate counsel reasonably declined to pursue testing the red cup as there was no evidence suggesting the victim's killer had drank out of a red cup. Let's see if that's true. I wonder if that's true. I hope if Control F doesn't work, I might not be able to do this. This is long. I like police reports. Actual Strickland standard, I do too. It's like flexible enough that you can nothing nothing is ever ineffective assistance. Willie Sallin. Is this one? I was not even planning on talking about this one today. Oh. There we go. This is just part. There's another. This is the witness. His testimony is used extensively in the trial. A subject known to him as Devin walked up. He said that he was drinking, turned up the cup he had in his hand, that I am going to murk him. And then he says I'm tired of him debugging me. That quote is used in every brief in that trial. This is used in every brief in a trial. But the testimony is There's this cup that was at the murder scene. So the habeas was wrong too, and the habeas counsel was wrong, because if there was anybody else's DNA, or even an absence of DNA, that would not only undercut, be physical evidence undercutting his guilt, but it would also call into question the entirety of this critical testimony. So it'd be doubly beneficial. And again, somebody else confess to the crime. So that's usually pretty compelling. I kind of sound like I'm joking, or like I'm making fun of somebody or down talking them, but I'm not trying to. It's like, this is unironically better than what Melly's getting. The average jailhouse brief with no help, with no guidance, is better. I routinely see jailhouse briefs that significantly outperform what Melly's getting. So, I mean, as if he could get some better representation. I feel like I want to end things on like a happy note. Have anything fun? I don't know. Anybody got any questions or requests, or I don't know, blind hatred that they want to share? Because that blind hatred can be fun. Interesting. Let's see if I can make this work. Oops. Definitely should have seen that. Any requests? I guess I can watch that. Ooh. I know what I want to talk about for 5 minutes. Are you planning to file any more motions? Yeah, we filed a notice of appeal. Hey, Keisha. Filed a notice of appeal on, what day is today? Friday? Wednesday? I haven't slept a lot this week. I've been writing so much, and I wrote there's a motion that's done. It's going to be filed. I was hoping today, but it'll be filed in the next couple of days, and then there'll be another motion after that, and then there'll be an appellate brief. I've written like hundreds of pages in his case. It's just frustrating because he's going to win. This case has been over for a very long time. There's no question that he's going to win. I can show you right now. It'll take 3 minutes. Oh, I hope there's something on here. So I was going to close some of these tabs. I have so many tabs open. You guys were right. Okay, that. Get my. Hey, puppy. Here we go. So this is why Muktuk is going to win and why he was subjectively right. This is the plea agreement that everyone talked about at trial. I need one more file, actually. There we go. Let's get the plea hearing transcript. All right, here we go. This is the plea agreement. This is insane, but that's not okay. That's not, the problem. This is the problem. This sentence right here. Now, if you look at the transcript, where is it? As to count 30, judge says, I can wait to sentence him, but he won't get released. And the whole thing is that he gets released. So, this is all impermissible, but that's okay. The judge says, sure, about the sentence. You have one of a couple options. You just can't do it this way. Referring to the sentence that we were just looked at. Or the agreement. Sentencing withheld. And judge says you can't do that. And then this is where the video cuts out during the YSL trial. And then this is where the actual sentence happens. Off the record discussion. They're, having negotiations. Here we go. What the state recommends at this time, the defendant be consecutive to 15 years. At this time, the defendant be sentenced to 15 years of probation on count 30. That doesn't work with this. That means that this agreement is not the one that was accepted by the court. And I know that. You think I'm just making that up. If you look at his sentence, it says, negotiated sentence, count 30, until the completion of the initial trial of this case. Which isn't a sentence. I don't know why I said that. Because they got rid of this part. That's so ugly. We gotta change that. Nope, that's worse. They're all bad. Okay. Until the completion of the initial trial, sentencing withheld. They're so bad, Kat. What was that? I should be in prison for that. That's the only answer. So, oh my goodness. This whole thing. Why does everything have LEDs? There are LEDs in everything now. Anyway, yeah, so this agreement, which you may remember from trial, from such moments as the defendant's factual acknowledgments, they don't matter at all because they don't exist. Because this document was rejected by Judge Glanville. So everything the state said is a lie. But unironically, everything they said was a lie. Sometimes for hours at a time. And so when Muktuk, being not an idiot or a liar, was handed this, He said, "That's funny. I'm pretty sure that I have a sentence on count 30 because, I believe in objective reality," which is a problem if you're dealing with Adrian Love. So he saw this and he thought, sentencing withheld, that can't be the right document. They must be lying to me. And so he was confused as to why somebody would be that stupid and irresponsible and, egregiously unprofessional, reprehensible both personally and professionally. So, he thought, somebody's lying to me. I can't trust this document. I don't want to say anything that I didn't agree to. And so, he's looking very suspiciously at this document, which again, he should have, because it wasn't the right document, because, the state was lying, or at the best, egregiously incompetent and should be disbarred. And yeah, that's what happened. Antonio Love, I can't believe I said that. That's a horrible thought. Antonio Sledge was right, and the state was wrong. Antonio Sledge told the truth, and the state was lying. It's not a matter of him being confused. It's a matter of the state lying. He was the only one who wasn't confused. Although he wasn't confused because he was confused, but that's beside the point. Anyway, it's showing that I don't need to explain that I'm right even more. But this is, again, the sentence. First of all, special conditions of probation, which you need to revoke a sentence for more than 5 years. There's nothing here. This is nothing. There are no special conditions there. And then the next section is called negotiated sentence. And that's also not a special condition. So you can't argue that these are special conditions, and there are no special conditions of probation here. The next thing you have is special conditions of sentence, which, much like Antonio and Anthony, start the same way, but they end differently. Special conditions of sentence and special conditions of probation they also start quite similarly, but they end differently. And just as if you were to arrest somebody named Anthony and attribute it to Antonio, that would be ridiculous. So too would be calling a special condition of sentence a special condition of probation when they have they're different things. So there are no special conditions of probation. So there were neither any factual acknowledgments nor were there any special conditions of probation. So Antonio Sledge, thanks, Kat. I was proud of that. It just came to me spontaneously. I wasn't last night thinking about the fact that Antonio and 16-11-131 and 133 all had the same number of characters. I was not thinking about how to work that into a joke. Actually, what's fun? I know what I want to do. You know what's going to make me happy? There's one person that can make me happy right now. That person is Adam Abate. That's true. We're going to play a game. Not the kind of game that, I don't know how. I'm so much happier now than I was 5 minutes ago. Look. Listen. He brings joy to my life. Not so much by his actions, but by his existence. The state's motion. So what we're going to do, you need to know, is that special condition of probation, like that specific term, is really important. There aren't many times in the law when having a specific, there's magic words, but in this case, these are magic words. Special condition of probation. It's capitalized that way, and especially in this case because you have special conditions of probation and special conditions of sentence. So let's see. I doubled the likes. Nice. Let's see if they actually say that Mutuk violated a special condition of probation, or if the state knew there weren't any and just kind of implied that there were those special conditions of probation and just kind of implied and alluded and innuendoed their way to it without having the courage or the integrity to say that there aren't any. I think you know which it's going to be. Plea of guilty. Oh, my words. Sometimes true. The general and special conditions of probation were detailed in the final disposition sentencing sheet. That is true. That's just by definition true, because that's the only place they can be, and there aren't any. But they are, that's where they are. Special conditions of defendant's sentence. Glanville imposed several special conditions on the defendant's probation, but not special conditions of probation, including a requirement that he fully adhere to all terms of the agreement. This is so dirty. I can't believe this is genius in the sense that it's competent. Usually they just do stuff that's funny because it's dumb. This is not dumb. It's just incredibly dishonest. He knows that there are no special conditions of probation, and he knows he can't say it, so he says special conditions on the defendant's probation, which is technically true because there are special conditions of sentence that relate to his probation, but they're not special conditions on the probation. What does he say next? Of pertinence to this motion are the following special conditions. Doesn't say it. This is the closest he gets. Special conditions of his probation. Notice it's the only one that he doesn't use the capitalized terms for. He's specifically not stating it as a defined term. His defendant violates special conditions of probation is the header, and right underneath it, he switches. Special conditions of his sentence. He doesn't say special conditions of probation, because these aren't special conditions of probation. During his testimony, the defendant directly contradicted the special conditions of his plea agreement, which, as you'll recall, that's actually an interesting one. See, a plea agreement and a sentence are not the same thing. They can be incorporated, like you can make the plea agreement a part of the sentence, but this is a piece of paper that is nothing. It was rejected by Judge Glanville. So if you want to say that he has special conditions of his plea agreement, that's fine. That doesn't matter, though. It's not a sentence. And they changed it anyway. They did, Cat. I'm trying to cut out misconduct, and you're just adding it back in. What's your Zelle? I don't know. I'm old. What was that? My. Also, that was funny. Trakisha asked you, and then you asked me. Is that the money one? Is that my phone number? I don't know how to do it. I'm old. My West. What's your social security number? I'm so mad now. He also confirmed that he fully understood the agreement. He did. You know what agreement he understood? This agreement, which, as you may recall, two things actually. One, don't say your number. I need to figure this. I'll figure it out. I'm old. Anyway. Send me an edible arrangements, but That's really funny, Kat. I should look into that. But Newton said, I have read and carefully reviewed this agreement. The plea agreement that was rejected, that doesn't matter. But what I really love about this is I fully understand this agreement. It's funny because nobody understands this agreement. Because the agreement doesn't make any sense because it's making up laws that are imaginary. So I promise you that he did. I mean, to be fair, the state also didn't agree to it or understand it because, they don't know the law, although Muktuk knows better than they do. So he couldn't possibly have understood it because it was nonsensical. Like saying, do you understand that the sky is whatever color the sky is not? Yellow? I don't know. Oh, God. Oh, man, but that one really weird judge will yell at me. What's his name? Jack Liu? Oh, man. Only the clerk got it. He didn't even, I mean, kind of. No, the clerk, I don't think the clerk did get it. I think he got a different issue. He got the issue with the withholding. He also should not have said all this stuff. But he was right, though. He's right about what he said. Special conditions of the plea agreement. Why did you change color? Okay. Understood the agreement. You didn't understand the agreement. Into the plea agreement. See, this is the one that drives me crazy. They say that Muktuk entered into the plea agreement knowingly and voluntarily. The state didn't enter into the plea agreement knowingly and voluntarily because they didn't know what the agreement was because they're incompetent. They didn't know the law. They didn't know the charges of their own indictment. You can't knowingly enter something that you don't know what it is. You might want to do phrasing on that one too, Kat. Evident. Okay. The special conditions of his negotiated plea agreement. Okay. He did not once accuse Antonio Sledge of violating a special condition of probation. That sounds really philosophical out of context. He was never accused of violating a special condition of probation. He doesn't have any special conditions of probation. He wasn't sentenced to any. I don't know what else I can break down because it's broke. It's also not without threat, but that's totally true. Oh man, R.I.P. threat. But yep. What else is there that I can? Yeah, let's do this one too. I don't want to say anything though. You will see this. They deserve, like, this isn't, if this were like they were serious people, I wouldn't treat them like they're unserious people, but they're not. They don't deserve respect. If they act, like respectable people, I'll treat them that way. Yeah, I mean, I don't really, I've thought about this more. I don't really fault Glanville for this one. because you can't rely on the judge to catch every mistake. He in his fairness, there were fewer mistakes because of him. He just didn't realize all the ways in which they'd messed up. Any more cases you're going to be covering? Yeah, sure. I can do anything. I mean, I know Tory Lanez has been one of the people I'm asking for, but I don't have a ton of documents for that. I don't really have enough to add any value, I don't think. But if anyone has any cases they want, and I can get documents for it, I'll definitely do it. I'd actually like suggestions. I don't know. Maxwell Anderson. Yeah, the thing is, I'm not covering the trials themselves. I really can't. I don't think I have that much to add because that's when they're just getting over the facts. And the facts are the same to everybody. I don't really have any I don't think I have a ton of insight on the I searched for a law in Florida instead of Georgia. That's why I was coming up. With Karen Reed, I don't really I don't mind doing it, but it's not like I have any more knowledge or facts or insight into facts than anybody else does. Are you marketing this niche expertise? No, I'm just consistently agreeing to work for free for people. Maybe though. I probably should get a job at some point. But yeah, I do like appellate work primarily. Where are you? There you are. Let's see. Is the right one? This one. I need to show you. This is the law that was in effect at the relevant time. One to 10, 5 to 10, or 5. I'm so stupid. I know what I should have done. This is what makes me happy. And cat happy. If you enjoy this, you need to get the website set up. Let me see. It's written. About the Keatley case? I don't know that one. Ice Cream Man? You, sir, no. You gotta get my attention. Is there like a murder? Is there an ice cream murder man? Did he go by like the Iceman? Oh my God. Okay, I'm not gonna make fun of the dog. He was waiting for trial for 11 years? That's wild. Ooh. Wait, which one is this? No. No, I don't have time for that. I think I'm gonna wrap up. There's an anger management program. I wonder if our boy ever took advantage of that. Because I gotta be honest, some of the professionals in that office have not exemplified, if I may be so blunt, the best control of their emotions on the witness stand. They're quite loud. Yeah, that one was. The DA dispatches are they're incredible. Yeah, this one was it. Just on this one screen, there are so many. Oh, goodness. I'm not going to say it. Okay, this. I wouldn't phrase that way. I could have applied for this. That would have been fun. I gotta say, this right here is the most offensive thing that they've ever done. This is beyond the pale. That's nearly a hate crime. Oh, I'm out of ideas. Oh, is this the one? I think I know what's in this one. With our guy? That's not the one I was looking for. Um, this. I wasn't trying to stop on this screen that's currently published by the district attorney's office. You know, the one that said that the person can't be seen, that one of these people can't be seen. Let's get to fix that. Okay. There's one of these that has a young person that you'll remember. I don't think it's this one. That's too bad. In Minecraft. What? Okay. Man, there's a young person. Alright, I don't think I can find it. I'll have to find it for next time. Ooh. I keep seeing stuff I do like that. I think I'll leave you this. It's the greatest footnote in the history of Georgia. Jimmy Winfrey. That's J is for Jimmy. I is for, I don't know. M is for me. M is for also me. Y is for you should be praising me. If you guys didn't see that, that was going to go completely over your head. Appellant Jimmy Carlton Winfrey pled guilty to 6 counts of violating the Gang Act in connection with the drive-by shooting of rappers Lil Wayne. Was it a drive-by if you're both driving? Anyway, drive-by shooting of rapper Lil Wayne's tour bus on Interstate 75. Also known as Lil Weezy, Lil Weasel, Lil Full Clip, Young Weezy, Weezy F Baby, Weezy F Crazy, Weezy Fizzy, Mr. Coach Carter, and Mr. Shoot 'em Down. His given name is Dwayne Michael Carter Jr. Beautiful. Just build the channel what you enjoy. Yeah, I have a lot of stuff that I want to get to. Some of it's going to take a really long time. Oh, this opinion's so good. The Supreme Court just annihilates the judge for the shit that she pulled. It's beautiful. Let's see if I can find one of those good quotes. Comments in this case crossed the line. Trial court made repeated statements. Blah, blah, blah. If you want to look around and see what happens to people in gangs in Cobb County. Where's that good bit? Yeah, I don't know. We can do it next time. Alright, I think I'm going to call it a day. It's been 4 hours. My goodness. That was a long day. But yeah, we'll have workouts soon. We'll have stuff on actual workout stuff soon for Moontunk. Which again, we're definitely going to win. The DAs are being moved around in Fulton. Judge preparing to call them musical chairs. I mean, maybe they could move further. All of them. Just like really far. They could, maybe move to Ohio or Washington. Canada. They could return home to the Seventh Circle. Lots of things. Oh, God. I feel like you should just be able to go into court and be like, can I have 5 minutes? No, they are not coming to California. They can... No. Canada's a good answer. Don't waste time on show. You know what? They can go hang out with Runkle. Maybe he can teach them how to, Runkle more or whatever. There are a lot of little remote islands up in northern Canada. Ask. Any idea how long it'll take to get a court date? It depends on which court and which way it happens. It shouldn't be that long though. Wait a minute, what date is the new trial starting? I thought it was June. Is it July? June 9th, jury selection? Is that right? Is YSL starting in 2 weeks? I was figuring the judge would want to get it done before then, if possible. So I assume it'll be pretty quick once the motion's filed. If there's even a need for a motion or a hearing. June, yeah, I thought it was June. That's crazy. That's tomorrow or the day after. See, I thought it was June, and then I thought I saw somebody say July, but I know it's June originally. Yeah, it's Demise, and the wild one. And I don't mean he's wild. I mean, just everything around him is insane. Maybe he is too. I don't know, but. Let's take a look at this one. There was this whole thing. Christian Eppinger. It's one of the two defendants left. Cops just came and seized the lawyer's laptop in the middle of everything. And they were litigating it, and Eppinger started dating one of the deputies. Well, and by dating, I mean, romantic rendezvous. Melly? I did several hours of Melly. I can... I don't think I can be any more harsh than I was on Raven Liberty. I probably should have changed the title though when I switched over. But yeah, I did like 2 hours at least on Meliscus. But yeah, Avenger started romantic pursuit of one of the courthouse deputies, and they ended up falling in love. I hope those crazy kids make it. We're gonna have to get into this at some point. But yeah, apparently the deputy was like chatting with him on IG in the middle of hearings from the lawyer's laptop. I don't know if that's true, but it's funny. All right, I'm gonna call it. Thank you guys for coming. If you have any ideas for like specific, I mean, I'll do the Iceman one or the ice cream guy thing for sure. But if you have any ideas, let me know. I'm tired. It's been such a long week. If an attorney can marry a defendant, I'm sure they can. Yeah. That was... Shannon's been on an epic winning streak lately. Shannon needs a TV show. Because... I never know what he's going to say, but I always want to hear it. Yeah, that's fun. I had a good time. Oh, man. I gotta figure out how to mix in some lighter stuff next time. I was depressing myself by the end of that Rape Liberty stuff. Alright, guys. But yeah, I'm gonna head out. I'm gonna get some food. So thanks for coming. And let me know if you have any ideas. Like, seriously, I'm not just saying that. Michael Keatley. Was that the ice cream? Was that the same guy as the... I know you said two names. He is. He really is. All right. Woody. Yeah, he is. He good too. Oh man. All right. And I guess my dog looks like it's about to bark, so I'm gonna head out. Like and subscribe. Oh man. All right. Have a good one.